Indian Dispute Resolution Centre, in collaboration with the Bar Council of India's IIULER, successfully hosted the third Arbitrate in India Conclave 2024 on 29 November 2024 at the India International Centre, Lodhi Estate, New Delhi.
Dispute Resolution Center. I'm delighted to welcome each of our distinguished guests, respected colleagues, esteemed panelists, delegates and participants present here today. The IDRC's third Arbitrate in India Conclave 2024 marks the fourth anniversary of the Indian Dispute Resolution Center. The event is being organized by the Indian Dispute Resolution Center in collaboration with the Indian International University of Legal Education and Research. That is an initiative of the Bar Council of India Trust, Pearl First, and is being supported by the Vienna International Arbitration Center, Austria. We embarked on this beautiful journey in May 2020 when Honorable Mr. Justice A.K. Sikri, former judge of the Supreme Court of India and an international judge, Singapore International Commercial Court, inaugurated IDRC. The IDRC is a not-for-profit institutional arbitration center. Its parent body, International Dispute Resolution Council, is registered with the Ministry of Commerce and Niti Aayog and impaneled with the Ministry of Law and Justice, Government of India. IDRC provides a state-of-the-art institutional environment for online and offline resolution of disputes through arbitration, mediation, and conciliation, as well as expert determination and early neutral evaluation through its cloud-based in-house EADR digital platform and through its affiliates in all major cities in India and overseas. We are proud to have Ernst & Young and Aditya Birla as our gold partners, and we sincerely thank their representatives for their incredible support and for joining us for the event today. Now, I will briefly take you through the flow of events for the evening. First, we will have with us Mr. Manan Kumar Mishra, sir, who will be delivering the inaugural address. Thank you for joining us today, sir. Thereafter, we will have the first panel discussion, and which will delve into the topic India as a hub for institutional arbitration, ad-hoc versus institutional arbitration. This session will be chaired by Honorable Mrs. Justice Hema Kohli, Madam, former judge of the Supreme Court of India, and it will be co-chaired by R. Venkatramani, sir, Attorney General of India. Joining them are Tejas Karya, sir, Head of Arbitration at Shardul Amarchand Mangaldas, Mr. Ratan Singh, sir, Senior Advocate and International Member of Keaton Chambers, and Mr. Arush Khanna, sir, Partner at Human Law Offices, who will moderate the discussion. After a high tea and networking break at 6:30, we will return for the second panel discussion at 6:45 on arbitration in banking and finance, the way forward. This session features Mr. Sanjay Agarwal, sir, Divisional Head of Retail Assets and Edelweiss Asset Reconstruction, Mr. Ajit Kumar Mishra, sir, General Manager of Contract Management at DFCCIL, Mr. Amit Goyal, sir, Partner in Forensic and Integrity Services at EY India, Mr. Asim Chaturvedi, sir, Partner in Dispute Resolution at Khaitan & Co., and Dr. Shashwat Bajpai, sir, Founder Partner of DRSP Chambers, who will serve as the moderator for that session. Thereafter, the valedictory session will be delivered by Honorable Shri Harsh Malhotra, sir, Union Minister of State for Corporate Affairs and Road Transport. We'll conclude with the closing remarks and a vote of thanks by Divyansh Anurati, Honorary Secretary, Indian Dispute Resolution Center. Now, I would like to welcome on stage Mr. Manan Kumar Mishra, sir, Senior Advocate, Chairman, Bar Council of India, and Member Rajya Sabha. Manan Kumar Mishra, sir, is Senior Advocate in the Supreme Court of India. Sir was unanimously elected as the Chairman of the Bar Council of India in the year 2014. Sir has been the forefront of championing the rights of the bar as well as advocating strong views on any attack on the judiciary of the country. Sir has promoted the standard and quality of legal education, right from promoting legal education in schools to establishment of India's first International University of Legal Research and Education in Goa in the year 2022, basking the success of a model of national law schools. It is our pleasure to be collaborating with the IIULER and Bar Council of India, sir. I thank Manan sir for his continued support and guidance to us. May I now please request Manan sir to please deliver the inaugural address and request Mr. Sanjay Rathi sir to kindly felicitate Manan sir before that.
A very good evening to all the distinguished guests, respected colleagues, panelists, delegates, and participants. It brings me great joy to address this esteemed gathering at the third Arbitrate in India Conclave today, hosted by the Indian Dispute Resolution Center, IDRC, in collaboration with the Bar Council of India and IULAR, Goa. I extend a warm welcome to all the present here today. The fact that we have gathered in such large number speaks volumes about the growing interest and importance of arbitration in today's rapidly evolving legal landscape. I would like to begin by expressing my heartfelt gratitude to IDRC team for their continued dedication and remarkable efforts in organizing this conclave, which provides an invaluable platform for dialogue, learning, and collaboration. It is also my pleasure to acknowledge the presence of esteemed individuals from across the legal, judicial, academic, and business communities. Each one of you play a significant role in the development and growth of the arbitration ecosystem in India, and your contributions are vital in positioning our country as a global leader in dispute resolution. The Bar Council of India has always been at the forefront of efforts to enhance the quality of legal education, practice, and professional standards in India. Through this partnership, BCI has worked closely with IDRC to ensure that the best standards are maintained in arbitration proceedings. We have strived to create a platform for the exchange of knowledge, experiences, and insights between arbitration professionals, legal practitioners, and academic institutions. This partnership has allowed us to engage in the development of arbitration practice while also enhancing the training and education of the next generation of arbitration practitioners. In India, the Vedic text mentioned dispute resolution mechanism resembling arbitration, with panchayats resolving disputes. The 1996 Arbitration and Conciliation Act aligned with the ancestral model law, reducing court interventions and ensuring finality in arbitration awards. Amendments such as 2015 reform further streamlined the process, introducing time limits for arbitration proceedings. India's potential to be a hub of institutional arbitration is rooted in our robust legal framework, our rich tradition of dispute resolution, and our growing cadre of highly skilled professionals. The recent reforms in the legal landscape, particularly the Arbitration and Conciliation Amendment Act 2019, were a landmark development. The amendment introduced several notable changes, such as reducing the scope of judicial intervention, ensuring quicker timelines, and setting up the Arbitration Council of India. Bar Council of India has on its part always led from the front by aligning its policies in this regard. BCI introduces rules and regulations for foreign law firms and lawyers in India. In line with global practice, the Government of India has proposed a draft Arbitration and Conciliation Amendment Bill 2024 to further streamline the arbitration process. Recently, on November 8, 2024, the Supreme Court of India delivered a momentous judgment in case of Central Organization for Railway Electrification. The five-judge bench addressed a pivotal question whether an arbitration clause allowing one party to curate a list of arbitrators from which the other party selects adheres to the principles of impartiality and fairness under the Arbitration and Conciliation Act 1996. In the context of banking and finance, where the stakes are high and the issues complex, the arbitration process allows for quicker, more expert-driven resolutions than traditional court litigations. Institutional arbitration centers such as IDRC offers the perfect platform to ensure that the disputes in these sectors are resolved by experts who understand the complications of financial regulations, contractual obligations, and international financial norms. It is essential that our legal framework continues to promote arbitration clauses in financial contracts and that the industry as a whole embraces arbitration as a tool for maintaining the smooth operation of banking and financial system in India. In addition to our work with IDRC, I would also like to mention the India International University of Legal Education and Research, IOLR Goa, which is a part of Bar Council of India's broader mission to advance legal education and research. IOLR is a forward-thinking institution dedicated to providing world-class education that aligns with global best practices in field of law. The university focuses on delivering specialized courses in various fields, including arbitration, international trade, and dispute resolution. Through its academic program, IOLR is cultivating a new generation of legal experts who will lead the way in promoting institutional arbitration and resolving disputes effectively. The Bar Council of India, through its partnership with IOLR, is committed to ensuring that the highest standard of legal education are imparted to students with a special emphasis on alternative dispute resolution mechanisms, including arbitration. As I conclude, I would like to reassert the importance of discussions and dialogues that will take place over the course of this conclave. This is a unique opportunity for all of us, legal professionals, academicians, business leaders, and arbitrators to come together and collaborate on how we can build a more robust and effective arbitration ecosystem in India. Let us make the most of this occasion to share ideas, forge new connections, and work together to ensure that India not only becomes a leader in institutional arbitration, but also remains a backbone of fair, transparent, and efficient dispute resolution worldwide. On behalf of BCI, I express my deepest appreciation to IDRC and all of you present here for your contributions to this field. Together, we can ensure that India continues to grow as a center for global arbitration and dispute resolution. Thank you once again. I wish all of you a productive and engaging session ahead. Thank you. Thank you very much.
Thank you, Madam Sir, for sharing your wisdom and thoroughly engaging words on the current scenario of arbitration in India, the challenges we are facing, and the roadmap we need to embark on for becoming the International Arbitration Hub. May I request the esteemed panelists to please grace the stage. I'm pleased to introduce to our esteemed panelists for the evening. I would like to request Honorable Ms. Justice Hima Kohli Madam, former Judge, Supreme Court of India, to please grace the dais as the chair of the panel. I invite our esteemed panelist, Mr. R. Venkatramani, Sir, Attorney General of India, as the co-chair. As the co-chair of the panel, Sir, Senior Advocate, Supreme Court of India, Mr. Tejas Karya, Sir, Head Arbitration, Shardu Ramanchand, and Mr. R. Khanna, Sir, Partner, Human Law Offices, and Ambassador India for the Vienna International Arbitration Center, to kindly grace the dais. With the due permission of our Honorable Chair and Co-Chair of today's first panel discussion, may we commence the conclave?
I think Matan sir is just on his way, so we'll just wait for him.
Now, I would like to introduce our esteemed panelists. Honorable Justice Ms. Hima Kohli Madam. Madam did her schooling from St. Thomas School, New Delhi, and graduated in History Honours from St. Stephen's College, University of Delhi. Her ladyship completed her post-graduation in History in First Division and thereafter pursued a law degree from Tax Law Center. She enrolled in the Bar Council of Delhi in 1994 after completing her law degree. Madam served as the Standing Counsel and Legal Advisory of the New Delhi Municipal Council in the Municipal Council in the High Court of Delhi, and was appointed as the Additional Standing Counsel for the Government of NCT of Delhi in the Delhi High Court. She has represented the Government of Delhi in several important public interest litigations. Madam was the legal advisor to the Public Grievances Commission, Delhi Pollution Control Committee, National Agricultural Cooperative Marketing Federation of India, National Cooperative Development Corporation, and other private organizations. Ladyship was appointed as an additional judge of the High Court of Delhi in 2006 and was appointed as a judge of the Supreme Court of India in 2021 and retired recently on 30th August 2024. Her ladyship has served as the chairperson and member of several government organizations and has played a significant role in their growth and development. Apart from performing her official duties as a judge, Madam takes a keen interest in promoting mediation as an alternative dispute resolution forum, in highlighting the role of the judiciary in preservation of the ecology and environment and the role of family courts in resolving family disputes. We thank you, ma'am, for sparing your precious time and joining us today. May I please request Ms. Ria to kindly welcome and felicitate her ladyship by presenting a memento and a telegram. Thank you, Ria. Next, we have with us Mr. R. Venkatramani, sir, Attorney General of India and a senior advocate with an enriching experience spanning over 4 decades before the Honorable Supreme Court of India. Sir enrolled with the Bar Council of Tamil Nadu in 1977. He has been appearing for the state of Tamil Nadu as a special senior counsel and also acting as a special senior counsel for the state of Andhra Pradesh. Sir is also retained by the Tamil Nadu Electricity Board to represent its cases before the Supreme Court and the Electricity Appellate Tribunal, New Delhi. Sir has also been engaged by the Ministry of Finance, Ministry of Railways, and Ministry of Health and Welfare as a special counsel. Sir has also acted as standing counsel for various universities and public sector corporations, counsel for the Supreme Court in matters pertaining to the employees of the court, co-opted member of the expert group constituted by the Ministry of Minority Affairs to examine and determine the structure and functions of the Equal Opportunity Commission. Sir was invited to be a member of the Ethics Committee of the Indian Council for Medical Research, member cum office bearer of several lawyers' associations, life member of Indian Society of International Law, resource person of the society for its annual summer courses, and actively participating in the projects of the society, member Indian Law Institute. Thank you, sir, for joining us today and being a part of this esteemed panel. We thank you for your time. May I please request Mr. Divyansh to kindly welcome and felicitate, sir.
Now, moving on to the next panelist, we have with us Mr. Ratan K. Singh, sir, Senior Advocate and International Member, Keating Chambers. Sir is one of the leading arbitrators and counsels who specializes in complex, high-value construction, engineering, infrastructure, mining, and commercial arbitration in India, as well as internationally. He is also an international member of Keating Chambers in London. From serving as the chair of tribunals to representing parties, he has a broad experience in international arbitration under the rules of ICC, UNCITRAL, SIAC, LCIA, DIAC, and many others. He is also the founder chairman of the Society of Construction Law India and director of the Chartered Institute of Arbitrators India branch. Sir has received several fellowships from numerous internationally reputed organizations. In fact, Sir is the only Indian to receive a fellowship from the International Construction Law Association. May I please May I please request Bhavika to please kindly felicitate, sir. Thank you, Bhavika. Next, we have with us Mr. Tejas Karya, sir. Tejas, sir, is a partner at Chardol Amarchand Mangaldas, one of the leading law firms in India, and also heads the arbitration practice of the firm. Sir has an extensive experience handling a broad range of complex, high-value international and domestic commercial disputes and frequently advises clients across diverse industry sectors. He has also contributed to policy formulation in the domain of arbitration. He has advised on the drafting of amendments to the Arbitration and Conciliation Act 1996 and the Commercial Courts Act, Commercial Division and Commercial Appellate Division of High Courts Bill 2015. He has also been a part of the high-powered committee set up by the Government of India for institutionalization of arbitration in India. Thank you for joining us today, sir, and making time for this event from your busy schedule. May I please request Ms. Janvi to kindly felicitate, sir? Thank you, Janvi. Next, we have with us, moving on to our youngest panelist and the moderator for the panel, Mr. Arif Khanna, sir. Arif, sir, is an advocate and legal consultant enrolled with the Bar Council of Delhi. He started his practice in 2012 after graduating from the Symbiosis Law School, Pune, and has also completed his master's from the National Law School of India, University, Bangalore. He specializes in commercial disputes with a key focus on arbitration, IBC, and antitrust. The list of clients he currently represents and advises includes Fortune 100 companies such as the Lenovo Group and Motorola Inc., and other multinational companies such as Corning and TGI Fridays. In addition to his commercial assignments, he also acts as a counsel for charitable institutions such as the Missionaries of Charity, Indian Cancer Society, and is also on panel with the Delhi High Court Legal Aid Committee. Arif sir is also Ambassador India for the Vienna International Arbitration, sir. We thank you for joining us today, sir. May I please request may I please request Yashma to kindly felicitate, sir? Thank you, Yashmit. Now I'd like to request Arush sir to please proceed with the panel discussion.
Well, warm greetings of the day to everyone in the audience. It is indeed endearing to see a packed auditorium on a Friday evening at this wonderfully curated third Arbitrate India Conclave 2024 organized by the IDRC. At the outset, I wish to express my heartfelt gratitude to the organizers for considering me worthy of such a unique opportunity to share the dais with such eminent stalwarts, all of whom have been tremendous sources of inspiration for an entire generation of aspiring court and arbitration practitioners, including myself. So the topic, or a part thereof, of today's panel is India as a hub for institutional arbitration. During the panel, our expert speakers would share their insights on the evolving landscape of the Indian arbitration regime, a concerted stakeholder movement towards making India an institutional arbitration hub and making institutional arbitration the norm rather than the exception. And we'll also talk about the role of courts as well as the bar, including the Arbitration Bar of India. Our experts will also be sharing their views on the recently circulated draft amendments to the Arbitration Act, including certain recommendations aimed at streamlining ad hoc arbitration. Speaking of ad hoc arbitration, a part of our topic today also includes a debate on institutional versus ad hoc arbitration. I'm particularly intrigued with the use of the word or the term versus. Are institutional and ad hoc arbitrations actually adversaries? In a massive economic landscape like India, do we need to do away with one to encourage the other? What may be too informal for an organized economy may be too prescriptive and costly for the informal economy, including our MSMEs. So on that curious note, I would like to ask my first question to the Honorable Chair. Ma'am, firstly, it's an honor to have you here, and it's an honor for me to share the dais with you. At a recent conference, you had advocated for minimum judicial interference in arbitration, restricted to only exceptional circumstances. You also alluded to the fact that in a modern progressive arbitration regime, both courts and tribunals ought to have clear demarcated responsibilities. Keeping with that chain of thought, what are your views on the prospect of having an appellate arbitral tribunal hearing challenges to awards using the same yardstick as courts? For example, public policy. Do you feel broader issues like policy of Indian law should be confined to our state courts instead of contractually agreed appellate tribunals? We can't, once you go to the court of your seat, you can't choose a judge, but you can still choose an arbitrator. Choice is often a privilege, but at times can be a problem. So, will this reduce court interference in the long run? So, ma'am, over to you. Thank you.
So there are multiple questions that have been thrown at me, as you can make out. And to start with, a very good evening. It's a pleasure to see so many of you here, and many of us who are serious practitioners. And happy to note that you've decided to spare your time and be part of this IDRC conclave. I hope that we will all pick up something from each other and go richer by the end of the day. So coming to this question that Arush has thrown, or should I say questions in plural. Yes, recently when I had gone to Dubai to attend the Dubai Arbitration Week 24 in November, I did say that minimum judicial interference in arbitration should be the focus of the court, and that it should be limited to exceptional circumstances for obvious reasons. The whole purpose of having this enactment in place was to ensure that if parties have agreed to a particular forum for dispute adjudication, then courts should be the last body to interfere, whether it was at the stage of appointment of arbitrators or in the course of the arbitration proceedings, or even when the award comes, unless and until those minimum parameters that are, and now they have been pared down, as we all know, over a period of time, since 1996 to now, where judicial interference is required. So if it really goes to the root of the matter, if it is fundamentally against the public policy and so on and so forth, I don't need to expound on it. You all know that those are those 3-4 criteria and no more. And nothing on merit should engage an appellate court. And when we say appellate, at that, as it stands today, before the amendments come in, there are still work under progress, the appellate would mean a section 34 or a section 37. But if there is an appellate tribunal within the arbitration setup as proposed, well, then that will also be guided by the same parameters that have been laid down for courts to adhere to. Minimum interference, unless it goes to the root of the problem, or it is a fundamental issue, or it's against public policy. Those are the kind of things that one would have to look at for an arbitral tribunal, which is an appellate tribunal, and confine itself to within those parameters, how much interference is required. So again, no interference on merits. If there is one view that is possible, then adhere to the view. Simply because the tribunal thinks the appellate tribunal another view is possible, it will not interfere, just as a court does in 34. And higher we go in the pyramid, the more narrow the scope of interference. That is the primary thing that is important. Coming to another question that Arush has asked us, do you feel broader issues such as public policy should be confined to state courts? Well, public policy's interpretation is different in each country. It can't be the same for one country and another. So when we talk of, when he's saying public policy to state courts, obviously he is talking of domestic arbitrations. But there can be instances in international arbitration too, when it goes completely against public policy, a particular nuanced award, then perhaps that window will have to be kept open for the courts to examine. I'm not saying interfere, I'm saying examine. And courts are careful in interfering in any international arbitration award. We all know that, unless it is imperative. It's normally a case of implementation of the award. where a party approaches the court after an award is made. So I think that it will be a very conservative approach that the courts have adopted, and a similar procedure, if implemented and legislated as proposed in the draft, would have to be adopted by the appellate tribunal within the arbitration regime, if there is such a tier opted for by the parties. Let's put it like that.
Thank you, ma'am, for your most valuable insight. I think the broader object and purport of what you're saying is essentially that clarity in circumstances wherein judicial interference, or perhaps prospectively interference by the appellate tribunal, is warranted, has to be clear. I think clarity of circumstances is essential for harboring any aspirations to becoming a hub for international arbitration. I mean, we all know of the recent ruling that happened in the DMRC case, wherein an award was interfered with at a curative stage. Now, whether that is right or wrong is a topic for perhaps another day. But I think clarity of the scope of interference is quintessential for us to be a hub. Now I have the honor of addressing my first question to the Honorable Attorney General for India, who's also our co-chair for today's panel. Sir, apart from being the leader of our bar, you're also the patron-in-chief of the Arbitration Bar of India. And on behalf of the young arbitration practitioners community, I can say with some level of responsibility that the launch of the Arbitration Bar has evoked a great sense of excitement amongst all practitioners, students, scholars, etc. That said, sir, a few weeks into the launch of the ABI, we saw a circular issued by the MOF, which called upon PSUs and other government bodies to refrain from taking recourse to arbitration in procurement contracts. Following soon after, sir, they were the draft amendments, which have also, as we see them today, raised a few eyebrows on issues like the lack of clarity when it comes to arbitrability of fraud, the reintegration of patent illegality as a ground for interfering in award in international commercial arbitration. Sir, do you think these moves stand to be obstacles in our march towards becoming a hub for international arbitration, or in your words, a global trendsetter in institutional arbitration? And my last question is, how does the Arbitration Bar of India plan to address these issues, if at all they are required to be addressed? Over to you, sir. Again, a couple of questions, not just one.
Let me start from the last question. It's better to start from the last. When the idea of an Arbitration Bar of India came into our mind, the question was, why do we have another bar? And if it's going to merely bring together practitioners in a certain field, then of course it could be a mere name and a mere grouping of people. But my idea was something beyond that. For long, we have been talking about ad-hoc versus institutionalization of arbitration process in India. Our transition from the 1940 Act to the 1996 Act has been fairly slow and for good reasons, bad reasons. The culture of the 1940 Act somehow got into our psyche, even in the 1996 Act. So for a long time, we were not able to get liberated from some of those very embedded principles in the 1940 Act. Then we were confronted with the situation that both in government and private contracts, the process of choosing arbitrators was left to the great glorified party autonomy principle. That ran into some difficulties in recent times. That's a different issue. So in that situation, one finds that ad-hocism was a necessary byproduct of a lack of attention to certain important fundamentals. But I suppose ad-hocism has also given us some lessons. We learned from that to find out how better and how good and how effectively we can bring about institutionalized arbitration process in India. without lessons drawn from ad-hocism, probably would not have been able to gather some rich insights into institutionalization process. And what kind of a trigger mechanism you would require to ensure we transition from ad-hocism to institutionalization? So in that context, I thought that we can have a dedicated bar which will probably spread its ability to influence ideas, practices, and procedures in all areas of arbitration, so that we're able to slowly move away from ad-hocism. I look at the Arbitration Bar of India as a tool, a very effective tool towards institutionalization, but there are other factors and players will do that. Government will have to do that, private entities will have to do that, but something which will facilitate and give a certain sense of strength and importance to the process, I thought, is an Arbitration Bar of India. Now, moving to other question. What has troubled me over a long period is the ethics part of it. And by now, universally, UNCITRAL or any other model have virtually laid down the foundations for the arbitration world. But even then, we have certain dragging questions. It is in those narrow areas of dragging questions where the ethical part of it comes in. We have examples like the MRC. So they don't really constitute the mainstream of the arbitral practice and intervention by superior courts. So having studied both as a practitioner of law, I would have been only probably practicing arbitration law. But having got into this position, one gets to know more closely what factors goes into constitution of a tribunal and what factors go into the conduct of proceeding before the tribunal, and many of those unfortunate things which can happen even in a government arbitration. So once you picked up those insights for what can make an arbitration process less holy, if you put it like that, then therefore we have to draw some lessons from that. So it is not therefore we can answer all questions about ethics in matters of procedures or streamlining procedures. So it is not that we will be able to go on a framework and answer the ethical question. But then ethical question and connected with the institutionalization have a certain connection. So if you have better institutionalization and more an inbuilt accountability and party autonomy, so that you're able to answer ethical questions, I think the need for courts intervention to a large extent will be minimized. Our transition or movement from the patent illegality, I think that's not going to be a major issue. But you enter into the public policy question, as Himakuri rightly pointed out, we have different legal systems where perception on public policy may vary differently, to a large extent or in a subtle way. When it comes to that, I understand in some recent arbitrations where I was myself appearing, so I asked myself a question: should I not refuse to let my thought process and inquiry go too large and too wide? So that I refrain myself from asking only fundamental questions. So as a practitioners of law, many of us are tempted even today because we are answerable and accountable to our clients, right? And therefore, I'm trying to understand and grapple with this question. You will find large number of literature in about international arbitration and the ethics issue. On a slight note of digression, we also have a cultural question. One of the books on culture of international arbitration begins with a story about a case from Africa. So the three arbitral tribunal members, one drawn from Australia, one from Europe, another from USA. Now, the witness who was to give a statement is from Africa. Now, a question is put to him. Question is about a color of a certain product. So you have a difficult issues in language. So if in an African language, orange can means red, right? So it can make a world of difference in the way one understands the process of arbitration. Why I'm talking about it, the culture of arbitration in India. Yeah, I've been traveling recently in different parts of the world. Look at how the arbitral practice in different parts of the world are functioning, taking stock of ethics and the culture. So it's in that context I thought an arbitral bar of India will make a world of difference. And I'm sure it's going to make a world of difference. So to answer finally, I don't think the circular issued by the government of India is going to be a big matter of challenge. And it is I think, a coincidence that the arbitration bar of India was born a little bit after the circular was issued. Probably an unfortunate coincidence. But I've been talking to the government, and the misgivings within government about why they need to travel into the circular, I also understood there are good reasons. So, but ultimately, it's all about the ethics of it. It's faintly reflected in the circular itself. But I suppose as soon as we are able to move into an institutionalization process, and we have many institutions, private and public institutions, IASC, etc., I suppose that they'll all be catalytic in institutionalization process. Over a period of time, the circular will probably die a natural death. I think it's better to allow it to die a natural death than to have an artificial engagement with that and to ask of it to die, right? I suppose we are confident as we grow into this that it will have a natural death.
Thank you so much, sir. I think your views are most reassuring and reaffirm the sense of excitement and anticipation that on the role of arbitration bar of India in really fueling India's growing aspirations of being an arbitration friendly seat. And sir, I think you rightly spoke about question of ethics and culture in arbitration. And ordinarily speaking, in law of averages, questionable ethics are normally more exposed or come to a forefront in ad hoc arbitrations. And speaking of ad hoc arbitrations, I will move on from one leader of the arbitration bar of India to another one. Mr. Karya, you have been one of India's leading soldiers in our march towards becoming a hub for international arbitration. Now, of course, we do have aspirations of institutionalizing the arbitration process and the entire regime in India. But numerically speaking, the ground reality is that ad hoc arbitrations still dominate the landscape. The draft amendments propose to actually institutionalize even the concept of an ad hoc arbitration. It actually empowers the council to frame model rules and guidelines for conduct of ad hoc arbitrations. Even the fees of the tribunal is now to be regulated by the council as opposed to Schedule 4 of the Act. Do you think this is a move in the right direction, sir? Or do you think it will increase surveillance, thereby curtailing the cardinal principle of party autonomy? So over to you, sir.
Yeah, thank you. As usual, you're asking multiple questions, so we'll answer that. But before that, good evening, everyone. It's my pleasure to be in the third consecutive Arbitrate in India conclave. I started with the first, second, and third, so I'm really grateful to IDRC for inviting me in all the three conclaves so far. And like previous edition, this time also we have the great speakers, and I'm lucky to have Ms. Justice Hima Kohli and also Attorney General for India and Mr. Ratan Singh, and of course our own Arush. Coming straight to the answer Arush has asked, this is the almost fourth round of amendments we are going to have in our Arbitration Act in last 1 decade, and we have come a long way in the journey of institutionalizing the arbitration in India. Traditionally, preference has always been to go for ad hoc arbitration, and we still continue to have many new contracts getting executed having ad hoc arbitrations. And the reasons are many-fold, and some of them is party autonomy, flexibility, less expensive. But I would say all this are arising out of lack of familiarity or the lack of experience of institutional arbitration by the users of the arbitration as well as the drafters of the arbitration clauses. And the way we have approached this issue is to introduce the institutional arbitration as an integral part of our legislation itself. And in 2015, when we first amended our statute since 1996, We have introduced series of amendments which are promoting the institutional arbitration. 2019 again was the second series of amendments where we introduced institutional arbitration, but it is a work in progress. We need to achieve the institutionalization over a period of time, but at the same time, we need to also address the ad hoc arbitration, and the best way is to address is ad hoc arbitration is to address the two aspects. One is the time, the other is the cost. And what the circular also which we see is as Learned Attorney General for India has said, they have genuine concerns, and we as an arbitration community cannot turn a blind eye about this serious concerns may it be coming from the government or the private sector. We need to address them straight and with the effective measures. And Arbitration Bar of India is one of the answers. The other answer is also to further amend the law to streamline the process, standardize the process of arbitration, and bring the certainty in terms of the time and the cost for arbitration. So I was part of just Mr. Vishwanathan committee, and we discussed and deliberated these issues. And one of them is to bring about a model rules for the ad hoc arbitration, so which is very similar to time-tested rules of all the arbitral institutions. The biggest advantage of institutional arbitration is that we have a set of rules which are applied to the arbitration process, which brings in the uniformity and conformity with the standard processes, which are the best standards across the globe we bring into the arbitration process. The Vishwanathan committee suggested the rules to be made part of the statute as a part of the one of the schedules itself, and give the power to the central government to amend those rules from time to time. Whereas the 2024 proposed amendment is proposing to introduce section 19(3), which will give power to the Arbitration Council of India when it comes into existence to make these rules, and the due regard will be given by the arbitral tribunal to adopt those rules. Now, there are a couple of concerns with this. One is these rules are not binding on the arbitral tribunal. They will only have a due regard to these rules, and these rules can be amended from time to time by the Arbitration Council of India. The other aspect is also party autonomy. Can the parties be forced to go have the rules adopted? This is very similar to IBA rules on taking evidence. This is soft law, whereas this will be neither part of the statute nor part of the soft law. So this will be something unique which will come through the legislation where the rule-making powers are given to the Arbitration Council of India. Nonetheless, this is a welcome step because it will at least bring in some kind of a guidance to the arbitral tribunals. When they adopt these model rules, they would be able to conduct the arbitration in the manner which is expected in any international arbitration setup. Even though it is in a domestic between two Indian parties, the rules should be common for both the set of arbitrations, international seated in India as well as between two Indian parties, domestic seated in India. So that is something we are trying to achieve. Now we'll have to see how the rules are framed, and the Arbitration Council of India will have to take the rules by way of a consultative process. The other aspect is the fees. What was happening is that Schedule 4, which was introduced by 2015 amendments, was criticized because of not adequate for all kinds of arbitration. Subsequently, the judgment by Honorable Supreme Court in FCON's case also brought about the issues with regard to Schedule 4. Mr. T.K. Vishwanathan committee suggested omitting Schedule 4 altogether, and also omitting Section 11A, which allows the proposed Section 11A, which will allow the central government to amend Schedule A. What we have now in 2024 is also to allow the Arbitration Council of India to propose fees where the fees are not fixed by the institution or by the parties. So therefore, there is that vacuum with regard to the fees is to be filled by determination by the Arbitration Council of India. Again, this brings slight kind of uncertainty, because for a particular arbitration, the arbitrator should be allowed to fix the fees if the parties agree for that, and the Arbitration Council of India can come up with the parameters for that which the arbitral tribunal may or may not accept. That is the best way for ad hoc arbitrations. For institutional arbitrations, of course, the institutions have their own schedule of fees. Many of the institutions have the cost calculators on their website. So if you know the amount in dispute, the entire fees of the arbitral tribunal as well as the institution can be known before even we start the arbitration. So that is something is very good to bring the certainty between the parties that what would be the cost of arbitration. With this new amendment of 2024, we have tried to ensure that there is a certainty, but this is not that transparent because we don't know what the Arbitration Council of India would find the fees to be an appropriate fees in a particular set of circumstances. So the best way is to follow the institutional arbitration, or at least accredit those institutions. Their fees can be adopted by the arbitrators, if at all, even in ad hoc arbitration. So we bring in the best of institutional arbitration into the ad hoc arbitration by adopting the rules, model rules, which will be applicable to ad hoc arbitration, as well as the standard set of fees which the institutions have already determined can also be made applicable to the ad hoc arbitration. Now, it will all depend on the Arbitration Council of India as and when it is formulated to implement this suggestion, because this only enables the Arbitration Council of India to make rules and prescribe the fees. Now, the manner in which the rules are framed and the fees is prescribed will have to be taken into consideration by the Arbitration Council of India, and also can be through a consultative process where the Arbitration Council of India can invite views from the stakeholders and then come to the conclusion whether how to frame the rules and how to prescribe the fees. But in all, it's a very positive development, and both aspects of time and cost is being taken care of by way of 2024 amendments. Thank you.
Well, I think those views are most useful, and I think there is a thin line between reducing the ad hocism in ad hoc and institutionalizing the process of ad hoc arbitration. One can only hope that the Arbitration Council of India, the rules that come out with regard to fee and the model code of conduct are they have certain clarity, and they really improve the quality of arbitrators. I think accreditation, whilst it's important to accredit arbitral institutions, I think accreditation of arbitrators is equally important as well, because I think where issues of ethics surface more to light and institutions like the government are opting out of arbitrations, I think these accreditations, genuine accreditation, will go a long way in resolving that issue. So, friends, from one very seasoned expert to another very seasoned expert, we have Ratan sir with us, who's been really a stalwart in this field for over 30 years now. Sir, I had again two and a half questions to ask you. I won't ask you three, as I've asked others, but Sir, the question that now comes is that, yes, there are no two views to the fact that institutional arbitration is the way forward. Yes, streamlining ad hoc arbitration is very, very laudable. But for institutional arbitration to be the mainstream option in India, it will have to percolate across the country. It cannot only be constricted to traditional commercial hubs like the NCR region, Bombay, Hyderabad, etc., where, of course, the shift is far more prominent. What challenges, sir, do you actually foresee in making that a reality? Do you think costs will play a factor? Because there is a school of thought that stakeholders feel that institutional arbitration, as I alluded to earlier, is too prescriptive and too costly. A lot of our MSME clients actually prefer ad hoc arbitrations. Could you just address some of these challenges that we currently face in India with regard to making institutional arbitration the norm rather than the exception?
Thank you, Arush. My Ladyship, Justice Kohli, Attorney General of India, Mr. Karya, Arush, dignitaries in the audience. Multiple question as usual, Arush. And you very conclusively said that institutional arbitration is way forward. And this is a statement which is coming from all quarters, and this is the way forward. I also agree with that. But ad hoc arbitration is the purest form of arbitration. Culturally, we always have had ad hoc arbitration. Subsequently, with complexities of transactions and requirement of more and more neutral decision makers, and because of trans-border transactions, we had institutional arbitrations coming in. Issue today, so far as India is concerned, I strongly believe that arbitration is as good as the arbitrator, whether it is institutional arbitration or ad hoc arbitration. Even if tomorrow you have all arbitrations going to institutions, will that really make the changes which we are looking at? Answer is no. First thing first, and you hinted on that. Quality of awards and the decisions which we see today, and we have been seeing for quite some time, is really a worrying thing. A couple of years back, I was speaking in a conference in Kuala Lumpur. And I was saying that India is the place to go to and so on and so forth. And lots of all law firm senior partners, the sitting judges, all were in the audience. Mr. Sundara Raju, Datuk Sundara, who is very popular name in India also. Sundara got up and he said, Ratan, but you have to tell us why it is that in India almost all arbitration award is challenged in courts. I gave my defense, whatever. I said that now we have a new regime in which you have to deposit the awarded sum in court only, then you can challenge and so on and so forth. But that is like sighing away from the reality. Justice Kohli talked about minimalistic judicial intervention. Why it is that almost every award is challenged, and why it is that good number of awards are set aside? If you ask me, only reason is quality of awards. And this happens for two reasons. One reason is that appointment of arbitrators, either by the parties or by the courts in default appointment procedures under Section 11 and so on and so forth, very little attention is given to the expertise of the arbitrator for that particular arbitration which is before the court. We have fantastic pool of arbitrators, fantastic pool of retired judges, good number of lawyers. But question is, every dispute is not meant for every arbitrator. Historically, arbitrators used to be domain experts. And unless we do it, the quality of award will suffer. That is one. Second is, even big names in the Indian arbitration circuit, sometimes when you come across the awards written by very big names, you think twice about the award. And one of the reasons which again I very strongly feel is that the the number of hours which were required to be given to writing of that award in that particular dispute was not available with the arbitrator. Professor Doug Jones, one of the finest arbitrators, particularly for construction industry, my very old friend, is my co-fellow in International Academy of Construction Lawyers. Recently, he was in India and Delhi, and we were having dinner together. He said, Ratan, I was sitting with one Mr. So-and-so other day, and I perchance asked him, how many arbitrations you are doing these days? You have running arbitrations. And that gentleman told me that he is currently doing 87 arbitrations. And Doug said, Ratan, I can't believe it. Why it is that? I'm not against arbitrators taking up matters which keeps them occupied and busy. Problem is the culture we have in India for deciding arbitral disputes. Cross-examination go on for years together. It is not happening in one stretch. Final arguments, oral arguments which we call it here, otherwise internationally we call it trial, which clubs both the examination in opening statement, examination in chief, cross-examination, oral submissions, concluding submissions. Internationally, all of this happen in one go. If we create a culture in India where arbitrators start a case and ends with that case on a particular day in a fixed timeline, uninterrupted, their whole attention for that week or 10 days will be to that case, and quality of award is bound to improve. Otherwise, what happens is, in a cross-examination, another thing, again it is a cultural issue, an Attorney General talked about that, the culture. In India, culturally, arbitration is just replica of court proceeding. Problem here is, in court today, your case is presented before Judge A, but at the time of final, arguments, or at the time of writing of judgment, you will have Judge B or C or G. Now, how to deal with that? One particular thing which is otherwise very prevalent in arbitration, whenever I sit as arbitrator, very first day, when I sit for any procedural hearing, by the time whatever paper I have, I would like to go through them and understand what is the real dispute. If you as arbitrator understand the nature of the dispute before you hear for that particular arbitration, you will be in command of the whole arbitral proceeding. You will be able to understand and decide all these interim applications coming before you. You will be better placed to decide discovery application. I was doing one international arbitration seated in India. We had gone for foreign experts and so forth, a lot of discoveries. One particular chairman of a particular tribunal says, Mr. Singh, do you think we know what is the real issue, what is relevant at this stage of discovery? I'm sorry, this is not how it works. So therefore, my suggestion is, one, that you need to have arbitrators who are specialized, or if that is not the possibility, because till now we have not created specialized bars from where you pick up judges in high courts and the Supreme Court. We are more like generalists, all of us. In that case, second alternative is that let there be continuous hearing. What is the effect of it? Effect of it is no arbitrator will be able to take 100 cases and 2 arbitration, 100 cases. Let one arbitration gets over, 2 arbitration gets over, you keep getting engagements. So quality really improves. Next, and we are talking about this guideline for the arbitrators. When you see the requirement of term of reference in institutional rules, what is this all about? At the time of writing term of reference, arbitrator is supposed to know what is the dispute between the parties and what is the position taken by the party. So, on the very first day, the least which arbitrators should do is, while issuing the first notice to the parties, let arbitrators write on the very first procedural hearing, let both sides talk about their cases in 20 minutes. Once you get to hear that, otherwise what is the culture today? Culture today is that arbitrators will open their file either at the time of final arguments or at the time of writing of the award. Once you understand the real dispute in the beginning or the first day, then with the kind of the legal brain we have in country, we can really do wonders. So these were my couple of suggestions. Thank you, Arush.
No, sir, actually. I think the applause also states that there are actually real-time challenges that we as an economy, as a country, which, as I said, harbors aspirations of becoming a hub for institutional arbitration. I think it has to also be a practitioners' movement, a stakeholders' movement. It cannot always be a statutory imposition or some draft amendments or some rules and regulations. I think you highlighted real issues like quality of awards, lack of expertise in our, in arbitrators. I think the choice of arbitrator has to be, today we are in an era of domain experts, horses for courses, as they say. We cannot have a particular arbitrator specializing in a particular practice area, being an arbitrator, arbitrating in over 80 arbitrations, which are completely alien to his or her practice area. So I think, yes, attention to detail is very important. It's very important for each arbitrator to understand his or her area of expertise, so that and work needs to be channeled and apportioned in that direction, in that manner. Sir, but you highlighted a lot of challenges and obstacles, but with the quality of speakers and the luminaries we have on stage right now, I can say this with some daring certainty that wherever there is a challenge, there is a way forward. So my last question is actually a common question to all. And I would actually start in reverse order, because the chair should have the last word. Sir, my last question to everyone is, it's a common question, and this is one question. Assuming the draft amendments are incorporated as is, without any change whatsoever, do you think they will grease India's wheels in its journey of being an institutional arbitration hub? If not, then what are your suggestions? One suggestion each. Ratan sir, if we can start with you, then we can go in reverse order, if that's fine.
You asked at least 3 questions from each panelist. So don't tell us one answer. I'll give you 3 answers. First of all, your question is, if draft remains as it is, I have one worry, and since the Attorney General is also sitting here, there is famous saying, if you throw peanuts, you get monkeys. It should not happen that while fixing the arbitrator's fees by the arbitration council, the kind of fee which are fixed should discourage good arbitrators from arbitrating. When you talk about good arbitrators, if you want to really make an institutional hub, you are using the expression, then you cannot exclude good international arbitrators, foreign arbitrators as well. And good size of disputes, complex disputes, require experienced, seasoned, generally busy arbitrators. So therefore, that is one caution. So far as your this guideline is concerned, I have one suggestion to make. there should be some talk about chase clock method, some hint about that, which is fixing of time. Like in international arbitration, we commonly see this, where both sides say, I have 5 witnesses, other side says, I have 10 witnesses, I have to argue this, I have to argue this. Tribunal will say, okay, we give you 3 days time, 4 days time, same timeline, days, number of hours, rather it is number of hours, number of 72 hours to one side, 72 hours to other side. Now during those 72 hours, it is your business, it is your decision how many witnesses you want to cross-examine, how many hours you want to argue, which witness you want to cross-examine, which particular issue you want to make submission on. So because Tejas also talked about that it should be time effective. How do you make it time effective? In one go, let us have a timeline fixed for parties. Another thing, very famous in all jurisdictions about Clatterbank thing, which is basically Clatterbank versus Clatterbank case, settlement thing. In order to encourage settlement, even there is a latest Australian judgment on this. During the course of proceeding, if a party gives a without prejudice offer to other party in a sealed cover, which sealed cover remains with the arbitral tribunal, tribunal will never open that till the time they are going to decide the case and award the cost. If there is an offer for 100 million to other side, today in the middle of proceeding, and that offer is not accepted, and tomorrow if that party gets less than $100 million, then in that case he has to suffer all the cost for the day, from the day when that offer was given. These things work really in a big way. So these were my quick 3 remarks. Thank you.
Mr. Karya.
Yes, so as far as the proposed amendments are concerned, all of them are good because it was pursuant to a exercise which was done by Mr. T.K. Vishwanathan committee. We all took feedback from all the stakeholders and then come up with the suggested changes. Some of them are very good. So one is the recognition of emergency arbitrators. That reduces the burden on the court drastically when we use the institutional arbitration and have the emergency arbitrator to decide interim measures, because that is something very positive step. We have been trying since 2015 to include emergency arbitrators definition into the definition of the arbitration tribunal, which would go a long way in recognizing that. The other aspect is the challenge of the award. Now, this particular round of amendment allows the court to partially set aside the award, but it does not allow to modify or change the award. So if you see the other jurisdictions like Singapore or UK, there is a power given to the court to change the award so that the another round of entire arbitration after setting aside of a part or the full of the award can be avoided. For example, the interest rates can be modified by the court under 34. Of course, the tribunal is given a lot of powers in the amended proposed amendments, but there are certain concerns like appellate tribunal. Now, who will sit as at the appellate tribunal, and whether we are adding one more layer to the whole delay process, because what would happen to the first award, whether it would be subsumed into the appellate award. That also will have to be seen, who will appoint the appellate tribunal. So there are certain concerns with regard to those amendments, but overall we need to see that how many times we will keep amending our law. And as Arush said, it's a mindset change which we need to do. Actually speaking, there is no need to amend the act if we amend the way we do our arbitrations. The easiest way is to decide the final hearing date on the first day of arbitration, as Mr. Singh said. You work backwards on that, have the procedural timetable PO1, the PO procedural order number 1, which is the entire timeline of the arbitration should be there and strictly should be enforced. And have the experts appointed as the arbitrators, again have the rules which are the time tested and the best rules, internationally recognized rules. There is nothing that we need to do which is not available, otherwise that we need to go back to the act and keep amending it. Because more we amend, it will give another round of interpretation to the courts. The courts will interpret those issues, then it will be a complex issue which one will be interpreted in which way. Then again we will go to 5-judge, then 7-judge, then 9-judge bench in Supreme Court to clarify small issues. We need to change the way we look at the arbitrations. We have to simplify it, streamline it, and do it in a more simple way. But of course, if we think that there is a need to have the arbitration regulated by Arbitration Council of India, which itself is a slightly concerning thing, because the earlier proposal was to have an Arbitration Promotion Council of India. The word promotion was removed from it, and now it's only an Arbitration Council of India. No other jurisdiction we have a regulatory body which regulates the arbitration. It's the parties who decide. It's an alternative or maybe a parallel to the judicial process, because some of the cases which go to arbitrations cannot ever go to the court because of the simple volume and the complexities involved in those cases. Plus the confidentiality. Nobody wants to go to court and wait for years and discuss their confidential information in the court. So the best way is to simplify the arbitration process. Do it in the way it should be done, and to be done by the experts who knows how it is to be done. And then we may or may not need the amendments as we are proposing. Thank you.
Now to our honorable co-chair, Mr. Venkatram.
Mr. Karya was talking about little skeptical about how many amendments we can have. I'm not skeptical about that. I think there are a couple of misgivings we have in mind. When people compare London, Singapore centers of arbitration, they are merely centers of arbitration. They are not nations like India, which in every economic policy decision we take, will have to be a certain amount of assessment and evaluation. So if an arbitral award or an arbitral process is going to have a certain economic impact on how you go about your economic policies, I think we stand alone. Now, recently, I had 2 arbitrations, particularly, for instance, take a gas and petroleum arbitrations. They are not merely a question of procedure, they are not merely a question of witnesses, it's a question of what something goes wrong in the entire procedure and the award, then you're looking at what happens to the entire industry. Therefore, I think if the amendments will probably deal with some of them, and we learn very soon that the amendments have not focused in the right direction, of course, I think Parliament will take a call on that. I don't think, after all, our Constitution has undergone more than 135 amendments, right? And somebody say US Constitution only 25 amendments, but they have too many problems there, right? Therefore, amendment is not an issue. And this where I think, again, as far as a certain area of flexibility is concerned, lawyers and the arbitrators can play their flexibility. There you don't need an external nudge. But a certain outer regulation, external regulations are concerned, they will have to be, I think, more firm. So the interplay between the firm regulation from outside and what an arbitral lawyer and an arbitrator can do in what fashioning your processes in every occasion you meet, I think there will be a good match between that. Today, because there is no good, there is a mismatch. Therefore, you have all the skepticism. I think as the arbitration bar goes, it will be in a position to say innovate and also create within its broader regulatory framework how you articulate your procedures as suitable to a particular arbitration. So I think that flexibility, if it is given in the hands of the arbitral process, India would have shined better. So I don't think we need to be too skeptical about all this. And finally, I said, as we're looking at the cost issue, either ad hoc or institutional, we will still face it for a period of time. and still we reach the plateau, right? I think we are yet to reach that. And recently I came across an arbitration which happened way back in 2011. The tribunal did not rule on cause. Then question arose, and how will they do it? Became functus officio. Matters went to Malaysian court, English court, and then landed on my table to find out what can be done now. So it was a difficult question for me to answer. So, but then I asked only one question: who all was responsible for this? So some element of responsibility will come around to the question of ethics. So ethics is not merely what the arbitrators fail to do, but every one of us who can add to the quality of the arbitral process. I'm looking at ethics from the larger meaning, not mere a moral issue. So I'm looking at it very differently. Therefore, I thought the arbitration bar would be in a position to probably bring in a lot of fresh insights and vigor. So we're looking at insights and vigor.
And now for the crowning moment and the final word.
I think we've all of us here I've heard my panelists, starting from Tejas and Ratan and learned Attorney General. The focus is, no doubt, there are amendments proposed and there have been frequent amendments to the enactment. We're also aware of the fact that by the end of the day, every amendment for one reason or the other is challenged in the court of law and travels right from the High Court to the Supreme Court, and the benches ranging from 3 to 5 to 7, as they just said. It's a fact. It's been happening. And I wouldn't be surprised that some of the amendments here, particularly the 2-tier one regarding the arbitration tribunal itself, would be open to challenge, though we know that there have been judgments by the Supreme Court, 3 judges bench on, which had decided that Centro, right?
Yes.
Which had decided that it is very valid, it is permissible. If the parties think that it is their autonomy, they want a 2-tier, there should be nobody to stop them, and it should be proceeded with further. So there could be a seat in India, which could be the first tier, and a seat in London, which could be the second tier, and all of that. So we know that there was Centro 1 in 15 or 16 and Centro 2 in 2020, which went on to hold that if it was the appellate tier, then the appellate tier's award was treated as a foreign award, only to be meant to be implemented here and nowhere else. So there are nuances attached to it. But I would say for us to go the institutional way, we need not only to focus on the ethics or the procedures or adopted by the institution, the ethics of the arbitrator should be squeaky clean. When we talk of international arbitrations, particularly so, that they're as neutral as they can be, with no tinge or no stigma attached to them. Similarly, for those who are in the arbitration field or practice, it is imperative that lawyers do not treat arbitration as a second fiddle, which is happening without exception in our part of the world. In nowhere else would any lawyer request a tribunal to fix a hearing at 4:30 p.m. The focus should be that if there is an arbitration that has to run, as Ratan just said, and it has to be time-bound, whether it is 72 hours or 160 hours, it should start in the morning as any matter would and go on and end at the end of the day, so that continuation is maintained. If there is a continuum, then the timelines will also reduce and everything will fall in place. But if we start at 4:30, after a lawyer has had a full day at work, he or she would be fairly exhausted, would like to wind up at maximum by 6:37. What would one achieve by the time you warm up in that arbitration? So again, it's a question of your approach and the mindset. That is equally important for promoting the cause of arbitration. Institutions, coming to institutions and institutionalization of arbitration, we haven't forgotten our cultures. We talk of traders' guilds for donkey's years. For centuries, India takes pride in traders' guilds. Those are also specialized arbitrators, aren't they? In a manner of speaking, whether it is the cotton trade, whether it is the spice trade, whatever it is, there were traders who would select their own arbitrators within their own field, who were specialists, who knew the nuances of that trade and would be the right persons to decide that dispute based on it. Today, we don't have spices or we don't have cotton, but we have oil and we have solar energy and we have windmills. We have all of that gamut, which also is a specialist field. So, as it has been stated by members, my co-panelists, specialization helps. And we should also remember, when we go the arbitration way, and when I say we, I include myself as having worn the mantle of an arbitrator, that one should be open to training, to learning, not just to proceed in an arbitration as if one was wearing the mantle of a judge. Sometimes you have to step back and learn. And that ongoing process of learning, whether as a lawyer or as a jurist or as an arbitrator or mediator, should never end. So that one goes back richer. And that is what I started with, that we hope we all go back richer with our interaction today. We go back richer in each arbitration proceeding and learn, and not at the cost of the parties, but having done some homework in advance of where we are heading and how would we take the matter further. That is imperative. That transcends all these amendments and drafts that we are talking of. We are talking of the foundations here, the very foundations on which this process and this whole building is to be built on block by block. When we go to the international platforms, which we all have been going, and tom-tom ourselves as one of the best venues for arbitration, well, then the proof of the pudding is always in the eating. We should be able to demonstrate that we are ready in any which way to compete with the best of the international institutions, with the best of the arbitrators, be a neutral field, and of course the best of the bar, of which Mr. Venkatramani thought about making, about making, and that is becoming a reality. Everything takes time. The seed is sown. It does, but we need to expedite. Otherwise, truly, on the international platform, we may miss the bus. It is imperative that we pull up our socks and get down to doing it. That is the bottom line, I would say. Thank you.
I think our learned co-chair wanted to say a final comment. Sir, by all means.
Everybody was talking to me about DMRC. So wherever I go, what about DMRC? I think I have only two comments. Like Antule's case, right? It cannot be used in all possible contexts. It is practically it's a standalone case unless you are able to creatively use it. I think DMRC is like Antule's case, like a pole star hanging somewhere in the sky, which will tell us what will happen when something goes seriously wrong. But that's my story around in DMRC. So I was very reluctant to push it beyond a point, but when we understood where the story was, then we had to do that. And
I think we now open the floor to the audience in case there are some questions. I think we can take 2 questions because I'm told the tea is still hot and the snacks are still good. So 2 questions in case. I think I can see one hand over there. Ma'am, can somebody file the mic? Yeah, great.
Check. Good evening, everyone. My name is Shani, and I'm a third-year law student. Sir, you specifically talked about the amendment of emergency arbitrator as a form of an interim measure. So, as someone who worked on comments for the draft amendment bill, that's one particular section I worked on. So, I was personally against that being implemented. So can we talk about how that may or may not affect party autonomy in case that's implemented? That's my question to you, sir.
I think this question is to Mr. Kari.
So your question is about emergency arbitrators amendment not being implemented.
So you talked about how that's one amendment you comment a lot, but I hold a contrary stance. So that's why I thought I should ask.
Okay. No, so ultimately the power to go to court under Section 9 is always available. Emergency arbitration is an option given to the parties who would like to go for an appointment of an emergency arbitrator, because there are clear advantages of emergency arbitrator is that you don't have to go to the court. The emergency arbitrator gets appointed within 2 days. Within 14 days, the emergency arbitrator comes up with a decision. That decision can be either amended, modified, or vacated by the regular tribunal as and when it is constituted. Now, what was happening is that unless and until we recognize that set of orders passed by the emergency arbitrators as if they are orders passed by the tribunal, although we had the case of Amazon versus Future, which Supreme Court has recognized that concept, but we needed to have the corresponding amendment to recognize that in the Act itself. And that is why we are now proposing to introduce Section 9A, which will recognize the orders passed by the emergency arbitrators as if they are the orders passed by the regular tribunal. Because the emergency arbitrator word or the concept was not there in our Act, which if we compare that with the other jurisdictions, they have already introduced that. We have arbitral institutions which provide for emergency arbitrators in India, but Act didn't provide for it. Therefore, we need to bring in that amendment by introducing Section 9A, which will bring in, of course, we have the judge-made law there, but if the statute recognizes, it will go a long way, and it will also promote the use of emergency arbitrators, which is reducing the burden on the court, because Section 9 court, it either goes to the district court or in the International Commercial Arbitration, the High Courts having original jurisdiction, it will go to the High Court. But we needed to bring that kind of uniformity with regard to the rules of arbitral institution and the Act, and that's why I thought that it is a very welcome step. Yes.
You take a contrary position on emergency arbitration, but I'm sure your position for arbitration would be that it is an appropriate dispute resolution mechanism. So you are convinced with arbitration as a very good mechanism. If you are, then you should be agreeing with the provision for emergency arbitration, because all the benefits attached to arbitration is attached to emergency arbitration. In last 1.5 months, I sat as emergency arbitrator in 2 matters, foreign parties, and in one of those days I sat till 10 p.m. and it was my the dispute was of my area of expertise, or whatever you call it, construction arbitration. I wrote 90 pages, one in 90 pages award and another in probably about 87 pages award, till 10, and both sides, and the timeline, you know the timeline. In that timeline, both sides' lawyer went completely satisfied that they were given fullest hearing opportunities. So the benefit which are attached to arbitration, that both sides get sufficient opportunity, they are heard by people who know the subject, who are ready with the file, who are ready to give the time. Because you don't get all of this in courts. So therefore, if you are happy with arbitration, be happy with emergency arbitration.
I think there is one more. Can we take up one more? So, can somebody just pass the microphone to gentlemen?
My name is Arvind Kumar. I'm a civil engineer and arbitrator. My question is to Mr. Venkatramani is about the new bill which is under consideration, and it is about the topic of fast track arbitration. It is there present in the existing bill, and it is there in the new bill as well. But this procedure is hardly used. Now, what is happening is, can we think of introducing a threshold limit, say up to so many million or so dollars or so many crore of rupees? If a dispute arises, it normally go for fast track mechanism only. I found out, I searched all the rules of Indian arbitration institutions. That threshold is not there, but I could find in ICC. It calls for a $3 million, if my figure is correct, as a threshold limit. Now, advantages are many to the entire arbitration space in India. It calls for only sole arbiter to be appointed. That means pressure on arbitrators' time is reduced. So if you want to have a continuous hearing for 3 days, 4 days, or whatever it is, it's not that you have to ask for 3 arbiters again and again. The point Mr. Ratan Singh said that, people have 87 arbitrations and things of that kind. If you have only one arbitrator or up to a particular threshold limit in government contracts or in PSU contracts or in other contracts, it will help a lot to the entire industry. See, what is the purpose of arbitration? The purpose is that can we do that in the new way?
In fact, this matter is receiving my attention.
Politely communicated that we will have to wrap up this panel now, and in case there are any questions, I'm sure in case our esteemed speakers are staying on, you can of course ask them and reach out. But today just want to conclude by saying that we are in an age and era of conferencing. These kind of events happen very, very often, but it is extremely rare to find such a high profile panel exchange such informative, engaging, captivating thoughts. So a huge round of applause for all our esteemed speakers. It's been an absolute, it's been an intellectual feast, right? So I think Sumedha, you have some announcements to make. Yeah, over to you. Thank you.
Thank you, Arisa. I'd like to thank our esteemed panelists for such an engaging and enlightening session. I'm sure the positive exchange of thoughts will help us take concrete steps to make India a hub of institutional arbitration. Thank you, leadership, for sparing your precious time and joining us today. I would like to thank A.G. Venkatramani sir, Ratan Singh sir, Tejas Karya sir, and Ash Khanna sir for joining us for the panel and discussion and being a part of the conclave and your continued support. We have a reflections board for sharing your thoughts and the feedback, so I would request everybody, and especially the panelists, to please share your thoughts on the board outside. Thank you, everyone, and I would like to request the panelists and audience to join us for the high tea break before we resume quickly for another engaging session on arbitration in banking and finance disputes, the way forward, and the keynote address by our chief guest, Shri Harsh Malhotra sir. May I please request for a group pitch on the stage, please?
Yeah, thank you.
Welcome you back to the second and final leg of IDRC's third Arbitrate in India Conclave. I'm Riya Rathi, co-founder of IDRC and member advisory board. I would like to introduce the topic for the second panel discussion, arbitration in banking and finance disputes, the way forward. It is universally accepted that the principles of natural justice must be followed in all the adjudications, whether judicial or quasi-judicial, by ensuring that the matter is decided by someone who is impartial and every party is given a fair hearing. Adherence to these principles in arbitral regimes is critical to enforcing faith in arbitration as a reliable area mechanism. Hence, arbitration legislations all over the world do not permit unilateral appointment of sole arbitrator. However, it is worrisome that in India, certain entities, including banks and NBFCs, are misusing the mechanism of arbitration when it comes to appointment of sole arbitrators. With an aim to contain this menace, the Arbitration and Conciliation Act 1996 was amended in 2015 to introduce Section 12, subsection 5, read with Schedule 7, which provides for a new ground to challenge an award if relationship of the arbitrator with one of the parties is such that it gives rise to apprehension about their impartiality. This provision was elaborated by Supreme Court in Perkins Eastman Architects versus HSCC India Limited and 3 judgment in TRF Limited, wherein it was ruled that a person who is not eligible to become an arbitrator
is also ineligible to appoint an arbitrator. In the case titled Haryana Space Application Center versus Pan India Consultants, the Supreme Court held that Section 12, subsection 5, read with 7th schedule, is a mandatory and non-derogable provision of the Act. Thus, unilateral appointment of arbitral tribunal is inherently illegal. A mere lack of objection by award debtor cannot be deemed to be an implied consent to unilaterally appointed arbitrator. It is not a matter of challenge or no challenge, because lack of challenge to something illegal won't make it legal because the law itself does not allow it. More recently, in a landmark development, the Supreme Court ruled that an award passed by such unilaterally appointed arbitrator is a nullity and hence it cannot be executed. These blazing decisions have been at the center of discussion ever since they came out. But these discussions usually remain confined to the legal fraternity. The vulnerable masses need to be empowered with greater knowledge and awareness so that they're in a position to challenge these illegalities committed against them. This issue has been flagged in Justice B.N. Sri Krishna Committee report and Law Commission of India's 176 and 246 reports, which recommended strengthening of independent institutional arbitration centers. As a result, Ministry of Law and Justice, Government of India, created a panel of arbitral institutions in India, and same includes name of IDRC prominently. Last week, the Government of India released a draft Arbitration and Conciliation Amendment Bill 2024, which primarily aimed at strengthening institutional arbitration centers. It is proposed that such institutions shall be granted appellate powers akin to the power of hearing Section 34 objection petitions. It is here that IDRC, as a robust, independent, and not-for-profit arbitral institution, pitches in with its in-house domestic arbitration rules, panel of independent arbitrators drawn from all the streams, including former judges of the Supreme Court, High Courts, PSU leaders, and domain experts. Now, I would like to request our esteemed panelists to please grace the dais. Now, I would like to introduce our esteemed panelists. Mr. Sanjay Agarwal is currently serving as Divisional Head of the Retail Assets Business at Edelweiss Asset Reconstruction Company Limited. In rich experience of over 35 years, he has headed various divisions in some of the largest asset reconstruction companies, including Asset Reconstruction Company India Limited. And as a group head at ICICI Bank, he successfully led the construction and professional equipment loan segments, significantly enhancing the bank's profitability. I request Mr. Chitragupt Dagar to welcome and felicitate Sir with memento and terrarium. Mr. Ajit Kumar Mishra is Executive Director of Dedicated Freight Corridor Corporation of India Limited. Having completed engineering at IIT Kanpur, he went on to do LLM in International Commercial Arbitration in QMUL. He has vast experience within the railway and track construction industry, most recently as Chief Project Manager for an international project. He has expertise in construction disputes as well as dispute avoidance. I request Mr. Ankit to welcome and felicitate, sir. Mr. Ankit, we are waiting for you. Mr. Amit Goyal is partner, Forensic and Integrity Services at Ernst & Young. He has vast experience in multi-jurisdictional investigations, forensic accounting, and dispute advisory in commercial and business disputes. He is a CFA charter holder and chartered accountant. He is adept at quantifying damages, delay analysis, and valuations. He leads complex client engagements across sectors like renewables, real estate, construction, and technology. I request Mr. Tanveer to welcome and felicitate, sir. Mr. Aseem Chaturvedi is a partner in the Dispute Resolution Practice Group in Khaitan & Company. He has been practicing for over a decade and regularly appears before all the forums, including Supreme Court of India, various high courts, arbitral tribunals, district courts, and consumer forums. Mr. Aseem has also been regularly appointed as an arbitrator in corporate disputes. I request Ms. Sumedha to felicitate and welcome, sir. Dr. Shashwat Bajpai is founder partner of DSRB Law Chambers. He completed his master's degree from University of Oxford, where he specialized in corporate business taxation and arbitration. He holds a PhD degree from NLU Delhi in transfer pricing and international taxation. His areas of expertise include arbitration, civil disputes, company laws, direct and international taxation, transfer pricing, and telecom law. I request Mr. Vikram to welcome and felicitate, sir.
Thank you.
Now we look forward to hearing the expert views of our esteemed panelists.
Good evening to all present here. At the very outset, I would like to thank IDRC, Indian Dispute Resolution Center, for curating this fantastic event. We have had an excellent panel discussion, and hopefully this one will also be. And thanks to Divyansh, Sumedha, and the entire team. Now, IDRC's motto is helping good people resolve. We have 4 such good people here, and hopefully they will be resolving some of our queries, your queries, with regard to a very interesting area, which is not the usual area we would discuss in conferences nowadays, but it's a very, very pertinent, interesting area, which is arbitration in finance and banking disputes. And what's the way forward? Now, we've decided to keep this session a very interactive session. We'll be having discussions amongst ourselves. And feel free to ask any queries, though we've reserved it at the end. But if you do feel that some questions needs answering, please free to interject us. Now let us kickstart today's discussion with the most basic of queries. And I'll put this to Mr. Chaturvedi here. Aseem, how have courts in India looked at arbitrability of banking and finance disputes especially concerning debt and recovery matters?
Thank you, Shashwat. Thank you for offering me the opening batting on this one. And I thank you to IDRC, thank you to all who are here. I'm sure you have better plans for a Friday evening, but you're sitting here to listen to us. So the question, I wish I could answer it in a yes or no, but the way we see it, it's really a conundrum. The Supreme Court has, in a recent judgment in Vidya Drolia, in fact, tried to resolve this, what we call as a conflict of polar extremes, that the issue of arbitrability of insolvency and bankruptcy claims really is, in terms of this judgment, not arbitrable, because they have kind of distinguished two sides of rights, which are rights in rem and rights in personam. As long as it's a right in rem, which is affecting the world at large or general application, it's non-arbitrable. When it's in personam, whereas it's an inter se between two parties, it's arbitrable. But it's still a grey area. As of now, Vidya Drolia has kind of shed some light, and it said that insolvency and bankruptcy disputes per se will not be arbitrable.
I must say our opening batter has done well. I'll put this to Mr. Agrawal now. Mr. Agrawal, tell me, how can arbitration frameworks address the power imbalances which are existing between large financial institutions and corresponding small borrowers, please?
I've spent a long time both as a lender as well as in asset reconstruction business as an acquirer of NPA loans. Somehow I feel that arbitration as a means to settle disputes between borrower and lenders has never attained its graceful place or respectability that it rightly deserves. And one of the reasons for that is this power imbalances that you've asked me. Every loan agreement has a clause where the lender can unilaterally appoint an arbitrator. The moment you say unilaterally, it loses its the credibility completely. And if an institution or a process which is about dispensing justice, which is not credible, it loses its the reason itself to exist. So not only appointment of independent arbitrator, but it should be seen as arbitrator should be independent, which means it has to be devoid of any kind of power imbalances. Now, I am sitting here at this forum where the Indian Dispute Resolution Center is there, which is organized by you guys. So one of the ways out is proposed by you, you yourself, is appointment of arbitrators by a distinct institution which is not the lender or the borrower. It gives an element of credibility and independence for the appointment. Nobody can challenge and say that the arbitrator is biased towards one particular party. And it takes away that the power, the component which a lender has. Having said that, I also feel they should also have an ability to appoint an arbitrator mutually agreed by the two parties. We can't necessarily impose that you got to go through this particular institution for appointment, or arbitrator. So maybe an institution like us or any bank can have a couple of institutions like IDRC on the panel who appoints arbitrator, and just in case the borrower or the other party says that I am willing to appoint an arbitrator with mutual consent, we should be open to that as well. So that's my view to remove the power imbalances here.
Thank you, sir. I'll slightly digress a bit. Since last decade, we've seen arbitration has become a norm as far as construction disputes are concerned, and especially in the big ticket matters between the public sector undertaking, the PSUs, as well as private infrastructure companies. And I'll put this to Mr. Mishra, who's been in hundreds of such arbitrations himself, sometimes as the perpetrator or litigator, and sometimes at the receiving end for private infrastructure companies. Sir, given the topic today, could you please give some insights and compare or distinguish between, for arbitration as a dispute resolution mechanism comparatively between construction disputes and banking disputes, sir?
Thank you, Dr. Shashwat, for first giving me the opportunity at the third batsman. And secondly, as bringing out that I am literally an odd man out on the panel. I majorly do construction disputes, either as a representative and or as adjudicator or arbitrator. And nonetheless, arbitration as a method of dispute resolution is a norm, notwithstanding the 3rd June Ministry of Finance guideline. It is the norm. Now, whether is any difference between construction arbitration or banking sector arbitration is there or not, my first answer and simplest answer will be, rather, if the dispute is arbitrable, if Mr. Asim has pointed it out, and if there are an arbitration agreement between the parties, then there is no, the Act doesn't differentiate between the two arbitrations. Be it banking sector dispute or the commercial construction disputes, it will be handled in the same manner. But yes, the process of handling those disputes by the parties and putting it before the tribunal will be very widely different. Why? Because the construction disputes are largely dependent on the technical nature of disputes, where a lot of technical interpretation, much beyond the legal interpretations, are involved in the dispute. And as you know, that there is no construction law or the specific act or law dealing with the construction dispute in India, in contrast to some other countries. Basically, the area is wide open for the arbitrators to understand and explain on those disputes. But banking sector disputes are largely in the financial in nature, arising out of financial regulations, banking laws, which are more simpler as in contrast to construction disputes to understand and to adjudicate upon.
Thank you so much, sir. I think while asking that query, I consciously chose not to refer to the Finance Ministry circular because there are several panel discussions and I'll be touching some wrong nerves there if we start discussing that. Now I'll put this next one to Mr. Goel. Mr. Goel, I must say that one of the hallmarks of arbitration is confidentiality. How do you address the privacy concerns which may be arising in arbitration because they'll be involving sensitive data when you're taking up financial matters, and where such privacy concerns may get amplified given the sensitive data involved?
Yeah, I think it's a very valid concern. I've been doing forensic work for the last 14 years, and confidentiality is always a central point of our work. Now, after a lot of laws has been there, regulations are there. First, we learned about GDPR. Then in India, we have the DPDP Act. So it has become more crucial, for professionals like us to re-emphasize the need of maintaining confidentiality. Now, if I talk about, how we practice confidentiality in our day-to-day jobs. So again, we are in a people business. We do a lot of teamwork. So the very first thing for us and which we are practicing is training our people on confidentiality. The very important aspect is training your people on the confidentiality, that what is expected from them, right? And I'll give you an example that, at our organizations and a lot of, leading organizations, they conduct regular training on confidentiality, and these are mandatory. In fact, it's part of the regular appraisal mechanism of the organization, that if you have not attended this training, then of course it will impact the appraisals. So that's one. A lot of organizations are more, very innovative around the confidentiality, and a lot of cyber attacks happening nowadays. So every 7 days or 10 days, there are simulated emails which are phishing attacks. So it seems like it's a phishing attack, and person has to, if someone acts and try to open that attachment, and say, hey, you kind of just misjudged this email, and if this would have been the real attack, then you would have been the problem, right? But then it also says that if you identify the red flags in that email, then it say, hey, congrats, you kind of, identified a phishing. So that's number one is training. Then it comes to when we execute the client engagements, then, at the very start, we sign the confidentiality agreements with our clients, as well as within the team as well. So every team member has to sign a confidentiality agreement. Okay. So that's on the, binding part and the training or awareness part, right? The second part is, how we implement confidentiality mechanisms. So obviously, there are a lot of, access controls as well as secure portals which are being used. So we avoid using informal channels like pen drives or, WhatsApps or any email communication to and from personal email IDs. We've used secure channels such as, data rooms, etc. And then we put access controls also. So it is not like that anyone can access that particular vendor data room. Only the specified people with the level of access they need to are only assigned. So that's one. Now the second part is, in a lot of arbitrations, when we do the banking related arbitrations or we do banking related forensic engagements, for instance, there is a lot of personal data we receive while we do the investigations. For example, if we receive a lot of employee details or customer details, it has the personally identifiable information. If we use it, first of all, we try to minimize the collection of that sort of data if it is not required, right? We say, okay, we don't need it, please either redact or remove it. In case we do get it, then we make sure that it doesn't come to EY. We try to work back with the clients that how to minimize exchange of that kind of information. And if we do get it, then we make sure that it is again redacted, used, and then disposed of as well in a proper manner and documented. So I think these are some of the protocols which we kind of practice. And also we do have incidents response plans and so on and so forth. So I think that's very important, and we practice on a day-to-day basis.
I think you mentioned a very important point with regard to the non-disclosure agreements, which I think should be made mandatory in financial arbitrations amongst all stakeholders involved in that arbitration. So, thank you. Now, if you see my friend sitting on my left, Mr. Chaturvedi, now Seema and I play a lot of cricket together. And we've always got this tug of war between us that who's going to bat first. Now, we've got a similar tug of war between arbitration and the IBC code. And it's been going on since the IBC's code's inception in 2016. Now, what do you think are the implications of the IBC to arbitrations, if we look at it from a financial arbitration perspective?
Thanks, Shashwat. So it's interesting because both arbitration and IBC are specialized legislations. It's not a specialized legislation with a generic law that the specialized legislation will prevail. But when we have a tussle of both specialized legislations in place, which one does get precedence over the other? While IBC is later in time, it's 2016, whereas the Arbitration Act was 1996. The IBC has a section, particularly section 238, which says that in case of any conflict, IBC will prevail. So when it comes to conflict between the two acts, IBC prevails under section 238. But what is interesting here is, and blame lawyers like us, who kind of come with very ingenuous arguments and interpretations. For example, in an arbitration clause contained in a financial document, it says that in case of disputes, parties are being referred to arbitration. Whereas the IBC in itself, if it's an operational creditor who's filing a section 9, where pre-existence of dispute in itself is a ground to throw out that petition, lawyers have tried to argue cases where they say because there's an arbitration clause contained in the financial document itself, it's a pre-existing dispute, therefore a section 9 will not be maintainable. So the Supreme Court has interpreted it and put this issue to rest, that in cases of conflicts, IBC will prevail, but merely because there's an arbitration clause contained in a financing document, that by itself will not be a pre-existing dispute, and it's not a tussle between an arbitration or an IBC. When we advise clients from a more practical aspect, they reach out to us that although this agreement has an arbitration clause, arbitration will be time consuming and will be cost consuming and to the detriment of lawyers and institutes like IDRC. They request us that why don't we first try our luck at an IBC proceeding. IBC these days is actually being perceived as a threat, and you first want to try your luck by sending a dispute notice or filing an IBC petition with the hope that it gets settled. But we kind of advise the client that you should be mindful of what the outcome is. IBC really is not a recovery proceeding. The purpose of IBC is either restructuring of the company or taking it in liquidation and eventually distribution of assets in terms of what the IBC provides for. So ideally, when it comes to overlap, yes, there is overlap, but both of them have a separate scope in terms of whether you're looking at recovery action or looking at an insolvency and a restructuring action. So that distinction has to be kept in mind while looking at or advising clients whether to go in for IBC or an arbitration. That would be my 2 bits to this.
Thanks, Susi. I'll put this next one to Ajit sir. Sir, there's a never-ending debate with relation to costs of an arbitration that has been doing the rounds since last 2 decades. Now, do you feel, sir, that arbitration cost may or will act as a barrier to the small individuals or small businesses if they come up for arbitration in the banking and finance disputes?
Yes, my simplest answer is yes. The cost of arbitrations are astronomically increasing. It's much higher than the Sensex nowadays. In the previous panel, almost everyone spoke about the arbitrator's fee, but that is only one component of that. Basically, the cost of arbitration is, if I can divide it into 5 baskets. The first one is the institution's cost, where you are filing your arbitration request, if at all. Then second one is the arbitrator's fees. Third one is your legal fee. Fourth one is, you can say, is about if you are engaging experts or some other thing, those experts' fees are there. And fifth one, you can put all others like your travel expenses, hotel expenses, and other miscellaneous expenses into that. So the first 2, that is the institutional fee and the arbitrator's fee, are generally ad valorem as per the institutional fee. So that depends on the value of your disputes. Not much of flexibility is there. But the other 2, the lawyer's fee and expert fee, is a mind-boggling. There is no benchmark to that, and there is a competition between the parties to engage. Not only the better lawyer, obviously, if that is the case, it should be acceptable, but rather going for the more costlier and costlier lawyer and experts. So this is jacking up the entire cost, and I don't know whether the results are in commensurate with those input costs or not, but yes, that is a deterrent to the smaller players who are looking at arbitration as a means of easy dispute resolution, which is cost effective and time effective as per the basic premise of the arbitration as dispute resolution. So this cost is a big deterrent to it. Thank you.
Can I just add one of my anecdotes to it? So we happened to do an international arbitration about 5 years back, and live transcription was not as frequently as we do now. There were only one entity who was doing it based out of Singapore. The cost of live transcription was more than our and the arbitrator fee put together. So that's the new norm. When you look at international arbitrations, you look at live transcribing, and that is phenomenally expensive.
Has been reduced significantly. But those costs has been significantly reduced nowadays. Now there is a competition between the King's Counsel and barristers who is demanding more fee.
When Ajit sir was answering his question relating to costs, I could almost hear him complaining to us lawyers, please reduce your fees now.
No. Especially not that. The reason for, your question was slightly different, whether it is a deterrent to it or not. Yes, it is. But once we are into the dispute and we want to get it resolved through arbitration, then obviously both the parties will put their best foot forward. And obviously, if I can recall what Ratan Singh said, if you throw peanuts, you will only get monkeys. So you have to pay good money to engage a good lawyer. I hope this clarifies.
Yes, this clarifies because I am one of his lawyers. So thank you. So I think I'll jump to a different area, and I think I'll piggyback on what Seem said about live transcribing. Now, live transcribing, VC hearings, we've seen this in the last 4 or 5 years post-COVID, the digitization. Now, I'll put this to Mr. Goel. Mr. Goel, what opportunities do you see digitization will have we've already seen this, that arbitration is really picked up in a better scenario when we talk about digitization, VC, etc. Do you think this will also help if there are arbitration in financial disputes?
Of course, it will help a lot. And I will not talk about regular stuff around the artificial intelligence or how you would digitize your entire legal documentation and save time. And I want to share the real world examples which we are practicing nowadays. And there are technologies and platforms available. And the power of those technologies are humongous. The technologies available, number one, have very strong, not just the keyword search capabilities, but the concept search capabilities. To give you an example, for example, you are digitally analyzing a person's data. It could be his computer system, it could be his phone, etc. And you want to identify that, does this person has any sort of financial statements? Then you don't have to put a keyword and search, okay, this financial statement. You say any document which seems like a financial statement, and the tools are so advanced that it will throw all the documents which are financial statements. Okay, that's another example. I'll give you another example of the capabilities where in good old days, people used to do keyword searches, and you are limited to do only the keyword search. Okay, you make 20, 30 keywords, and you are limited to those keywords, and then you have to redesign those keywords and redo it, right? And if you're not smart enough, you will not get the desired results. But now the capability is there where the tool itself will drive you. But are you getting to the desired result with your initial keywords? Or should I give you better keywords based on your objectives? So that's another capability of digitization, the technologies, the AI-powered technologies available. I'll give you another example. Okay, these 3 examples I would put, then I'll move on to another thing. So let's say you are doing a case, okay? And in that case, for example, construction case you are trying to do, okay? And you have the entire documentation which you have kind of created, digitized, and fed into that tool. Now, you only have 4 or 5 days to do a very preliminary assessment. Are there any delays in this project? Okay. How can I get that answer? So the tool is capable to say, are there any delays in the project? They'll say, yes, there are delays in the project. What were the 10 factors which led to these delays? It will answer, these are the 10 factors I identified from the data available which led to the delays. It could be land acquisition issues, it could be right-of-way issues, it could be approval issues, etc., etc. It will not just give you a very basic answer. It will give you all the documents based on which it is giving you that answer, and it will create an index. Then imagine how easy it is for lawyers or forensic professionals like us to determine very preliminary facts of a case without spending months and putting a battery of 10 lawyers or 20 forensic professionals who go through the huge amount of data to answer a few basic questions. Of course, you have to put your intelligence into it, but the tools are available, technologies are available. So that's one advancement which I am seeing globally happening. And I think India is no behind. I think they will catch up soon. A lot of law firms, I think, adapting to those technologies. I think the second aspect which I have seen, and I don't want to touch upon too much on it, is the digital hearing. In the old days, digital hearings were not there, but after COVID, we have seen it rising, and it is still happening. And I think in many international matters, US matters, in fact, Indian experts are able to participate in the cross-examination, provide their expert testimonies as well, while not traveling to US or while not having any visa for the US. So that's another advancement, I would say. And apart from, there are other tools available, technology tool, analytical tools, which are there, which we see on a day-to-day basis.
Thanks, Mr. Goyal. If I may ask Mr. Agrawal this next question. We all know, so there's a mountain load of non-performing assets that we have now in India. How do you feel the arbitration mechanism can assist in resolving disputes arising from these NPAs with due deference to, without relying solely on the debt recovery arbitral tribunals?
To start with, I would like to say that DRTs and SURFACE Act have done a very good job for the financial sector. We actually depend a lot on SARFAESI Act as well as DRT. There are of course challenges, and there are some issues that are developing, but then it doesn't take away the success of these two tools that we have with us. But of late, it's sort of a trend is coming where DRTs are also getting overburdened. There are cases where POs are not there. So somewhere we feel that DRTs have reached a sort of capacity at many locations. So if there is any mechanism which can lower the workload with DRTs, it should be appreciated. This is one. The other part of your question was that, how can arbitration help in dispute resolution? Today, all the newspapers are full of two critical segments where the NPAs are burgeoning. One is unsecured. RBI has been warning the banks for a long time, and now suddenly in the last quarterly results, we see that unsecured NPAs have gone up, ballooned up like anything. And second segment, which is also showing signs of stress, is affordable housing. Now, affordable housing is also one of the focus areas for us as a country to improve the housing situation in the country. Now, both these segments are actually not sort of in purview of DRTs. And even if we go to DRTs, for let's say affordable housing, somehow somebody goes there, we won't get a response properly. So arbitration is probably the only way which we can address this very large mass of non-performing assets which is getting generated by the lending world. Coupled with that, if we see a situation where younger borrowers are becoming more and more aware, and they are more concerned about their credit history, they got to borrow in future, they don't want to spoil their credit record, which means they don't really need a law kind of solution. They need something which is somewhere between the DRTs and pure law, and something like arbitration, which is a little softer. So online dispute resolution kind of thing which are being offered now, which are available now, if they become popular, they are the best way to address a very large volume of smaller loans, unsecured loans, and unsecured could even be slightly bigger loans, because DRT, even if you go to DRTs, the process becomes longer there. So today, particularly for business loans, we see cases where even 50 lakhs loans are being given which are unsecured in nature. So there also arbitration can play a very, very big role. We feel that arbitration as a tool is underexplored. If we are able to put our house in order, the process in order, this is going to do a great deal of service to the ecosystem, whether it's the lenders, or the borrowers, or entities like us.
I think it's a very Anglo-Indian and interesting perspective that has been brought. But I see a hand being raised before I ask the next question. Please, sir. Can someone please hand over the mic?
This distinction between IBC and arbitration. What is the meaning of arbitration? Assertion of a right by one party and denied by the other. Does the IBC have the powers to decide the dispute? That's one. The other contradiction is the whole purpose and object of this discussion was to understand whether institutional arbitration should be the talk of the day. I mean, is this important that the government of India must encourage arbitration clauses to be inserted in banking and non-banking finance companies agreements? Even if assuming there is no such clause, by an agreement between both the parties can agree to refer a dispute. If you are in control of your borrower, and I'm in this field for many years, you can bring the party to a settlement. This mediation in Delhi High Courts and mediation by the trial courts, the mediators are not well versed with the arbitration or mediation laws. So it should be an institutional arbitration. If you have to go under Section 11, let the courts refer the disputes to arbitration. And I think there will be faster disposal of banking disputes. DRTs are overloaded. It's very strange. I mean, you go for a 2 crore debt recovery and they say we have no time for 2 crores, matter is kept pending. For them, 2 crores doesn't matter. They are looking at 200 crores. So even in the public sector entities, even if there's arbitration and you have all the reliefs, you've got Section 9, you've got Section 7, why do you read Section 9A, emergency? Do we even use Section 9? How many companies are using Section 9? How many are using Section 17 of the Arbitration Conciliation Act? It's a highly undermined act. We are all going to IBC, winding up all the corporates in India. There will be no invest in India. The companies will be wound up and taken up. So I don't know what is your...
So I completely echo your sentiment. And it's my personal view that DRT as an institution, sir, maybe because of the lack of the will to put in more infrastructure. I don't know if you've appeared recently in DRTs. I think it was one of the last tribunals to get VC facilities. Our focus right now is shifted from DRT to IBC. It's a newer legislation. It's had so many amendments. It's got all the teeth. Let's focus on something which is new. It's very human. Whatever is new, let's focus on whatever is new. Forget about the earlier legislations. But personally, what I have seen, if you're looking from a lender perspective, DRT is still one of the most sought after remedies because the immediate attachment provisions are there. Under SARFAESI, immediate possessions can be taken. The other advantage that is there in DRT is the moment you get a recovery certificate, the appeal to DRT is at a pre-deposit. That pre-deposit is missing. Even there is absolutely no pre-deposit when it comes to IBC. IBC is something which is a different ball game altogether. So one needs to really see that whether you're going after recovery or you're going after restructuring and insolvency, what I was suggesting in my earlier answer. But I completely with you, sir. There are three different regimes and we must give more teeth to DRT. DRT must get better infrastructure, must get more officers. We are an issue of, if I will not say the laws are in place, the abundance of litigation is what is bringing us down. IBC will see the same fate. We are seeing arbitrations being facing with the same fate. We are seeing amendments after amendments after amendments. In the earlier panel, they were saying there are certain arbitrators who have 100 arbitrations. They have a cause list of arbitrations. That is what not arbitration was for. Arbitrators were not supposed to have cause lists. The whole purpose of arbitration was alternate dispute resolution mechanism. You go in for a quicker remedy, but even now, sir, if you look at a timeline, arbitration still has a certain timeline. It may be 18 months, 24 months, at best 36 months, which even IBC, which was supposed to be 330 days, no resolution happened in 330 days. DRT, forget about it because DRT is a backlog. You're absolute, I echo your sentiments, sir, but IBC arbitration is and should be explored more insofar as your lender-borrower disputes are concerned. And we'll be happy to chat offline. I don't want to eat on to others' time. The other panel ate into our time. I don't want to eat into your dinner time. We can separately take this offline, sir. Thank you so much.
I'm certainly going to use this phrase of yours, cause list of arbitrations, in the next panel discussion, hopefully. So, in fact, the gentleman asking the question actually pointed an important aspect about mediation. And that brings me to my next question to Mr. Mishra. And this is the question which, in fact, in all panel discussions where we're talking about arbitration is asked. How do you perceive, sir, if we have a hybrid model of either ARB-MED or MED-ARB in complex financial disputes? Can we go ahead with such kind of hybrid models, arbitration, mediation, or just mediation itself? What's your take on that, sir?
Yes, that's a very interesting question. And this question is lingering since so many years in the legal fraternity. It has different understandings, but if you are asking about my personal opinion and experience, all I'll say that this hybrid mod is always preferred, because then you are able to actually harness the complete advantage of your alternate dispute resolution. Because what happens today, if you have only arbitration clause, if arbitration fails or you have an appeal against that, you again have to enter into the litigation channels. But if you have a clause like ARB-MED-ARB, if during the arbitration the arbitrator may offer the parties to go and try for mediation, although section 30 provides this, but that's a more formal one where the arbitrators are obliged to refer the or offer parties about the mediation. And if there is a mediation settlement, then it will be issued as a decree of court, like the arbitral award. Or even if that fails, mediation fails, then again the arbitration can be resumed and things like that. So it is always good to have clause like this, and a pioneer institution in this, I'll say, if I can say so, is the SIAC, where they have this in their clause itself, they have a joint kind of statement where the arbitration will be held under SIAC and then mediation will be held under SIMC in the same text. So the arbitration clause is put like this, that if the arbitration fails, then party will refer the dispute to mediation under SIMC rules. Things like so, it will be always beneficial to have a clause like this and refer the disputes to through this composite mode of dispute resolution.
Thank you, sir. Now, coming to another important issue, which is again been a bone of contention in several arbitrations, which is pertaining to experts and experts' witness testimony. And who better to answer that than Mr. Goyal? Mr. Goyal, I would ask you, what role can a financial expert or a forensic accountant play in arbitration proceedings? And what complexities may arise if he is to be treated as a witness or if he is giving an expert witness testimony in a complicated financial dispute arbitration?
Thanks a lot for bringing this question. And I would first start with, sir raised a question, a lot of exorbitant money is spent on the experts, where I kind of see that, the experts bring a lot of value, okay, and they really do a lot of hard work. And similarly, the lawyers also bring in a lot of value and they do a lot of hard work. So I think the cost, I would say, is justified, and I'll tell you why it is justified. One is that expert's role is not give you an expert report, appear in the cross-examination, provide his testimony, and then end of the matter. Expert role starts from very early on if the claimant or respondent wants to start. Okay, so expert role could be before you file a SOC, you can bring in an expert who can help you to identify various your claims, identify various facts. He can go hand in hand in working with the lawyers to do the litigation strategy also, because to assess your merits of the case, sometimes fact finding is very important. That's where I think the experts can bring in a lot of value based on their sound analysis, review of a lot of information, financial data, and then telling you, okay, is your claim not on the grounds of legalities, but based on facts and evidence is robust enough or not. That's one. Okay, so bring in experts early. A lot of clients I have seen who kind of end up doing calculations in a very ad hoc manner, filing SOC, and later on, very, very silly mistakes in computations can change the value of your claim by hundreds crores, 200 crores, simply by taking the wrong interest rate or simply by taking wrong dates. These errors can be avoided if you, bring in experts early on. So that's one. Now it is not just, having an expert for preparing a claim or SOC. You can have an expert if you are on the other side of the dispute as well, where an expert can critique the claimant's claims as well on the basis of various facts, evidence provided, or simple commercial or business logic. Okay, so that's the value experts bring in, number one. Now coming to the when the arbitration proceeding starts. So when the arbitration proceeding starts, experts can again, as usual, they will be part of the cross-examinations process or discovery process. But there also experts can also help your lawyers that what kind of questions you want to put to let a lot of other parties, fact witnesses, other parties, experts as well. Because if you find out issues, then it is always an edge for your lawyers and counsels. Okay. So I think that's the role experts are kind of, and bringing a lot of value. And it all depends when you involve them. Okay, if you involve them at the very last stage, then it will become, a challenge for an expert to add value. Now coming to the challenges in this process. So I think the number one challenge is, as I just mentioned, bringing in experts at a very last stage, giving them very less time to independently analyze the information and give their opinion. So at times it's a very, I would say, then the value addition will not be much. The second aspect, which is very important in our business, is the maintaining independence and objectivity. So experts has to be independent. They should not appear as a as an advocate of their clients. So we have to, although we get our fee from our claimants or respondent side, but we have to be independent. Our duty of care is to the relevant arbitration tribunal or whatever court or forum is there. So our duty lies with the court and arbitration. So independence, maintaining independence is very difficult challenge at times where you are working for a client and client may be upset. As an expert, you are not giving them a desired claim value which they believe it should be based on your opinion. So that's another challenge. And the next challenge is resolving conflicts. Because at a lot of time we are not just conflicted with our clients. Sometimes we are conflicted with the other parties as well. So these are the two key challenges. The third challenge where expert and I personally see is the availability of quality information and documentation. So at times experts has to apply a lot of judgment and empirical research and data because the claimant doesn't have enough information to support their claims, and it becomes very tricky where the expert feel and he has a conviction that yes, claim is there, but it becomes very difficult to justify this based on the available information. So I think these are the few challenges where an expert, and again, last but not the least, facing the stress of cross-examination. So I think that's one challenge, but yeah, it's part and parcel of the job.
Spoken from the heart of an expert, I must say.
My disclaimer applies on experts' fee also.
We appreciate that, sir. Asim, if I may ask you now, what do you feel are the inherent conflicts between specialized financial tribunals compared to the arbitration mechanism in India, and how do you feel that the Arbitration Conciliation Act 1996, of course amended as of date, align with the specific requirements of such financial disputes that we've been discussing?
So, Shashwat, I will not say there is an inherent conflict. There is certainly an overlap. By overlap, I mean that again, you go back to whether you're looking at recovery or whether you're looking at a restructuring. If you're looking at recovery, there is no better legislation than the Arbitration and Conciliation Act. However, the overlap and the conflict really, it lies in the fact that the Act does not define what dispute is arbitrable. We've had series of judgments interpreting whether it is arbitrable, it is not arbitrable, and they all end with one simple line that it will have to be decided in the facts and circumstances of each and every case. So for better clarity, if the Act or whether we have the 2024 amendment, whether the 25 amendment, if it provides that yes, this is an arbitrable dispute, this will be arbitrated. I think if financial disputes are categorized as arbitrable disputes, whether it's insolvency, bankruptcy, it will be a step in bolstering arbitration in terms of the preferred choice when it comes to financial disputes. That number one. Secondly, even if the arbitration clause which provides for the disputes of insolvency, bankruptcy, which we know will not be arbitrated, that clause itself cannot be challenged. You'll have to go through the rigmarole of arbitration. Eventually at the stage of 34, you may realize that what you ended up doing for the past 2 years was not arbitrable and the award is set aside. So that I think is a conflict where you need to have clarity on whether a dispute is arbitrable or not. There are certain clauses that we've seen which restricts that for insofar as recovery is concerned, it will go to DRT. For everything else, it will come to an arbitration institution. Now clauses like these are which create confusions and ambiguities and conflicts. So at the stage of drafting of a lending agreement, I think that's where clarity is required, that what exactly are you looking at? Whether you're looking at pure attachment under the DRT Act, or you're looking at wholesome recovery under the Arbitration Conciliation Act, or you want to just exert pressure and take the company, so to say a corporator, under the insolvency route. Because what we've seen, the biggest haircuts are being taken is by banks and financial institutions. A corporate debtor, once it goes into insolvency, a resolution plan comes in, the biggest haircut is really by a financial lender and nobody else. So the overlap needs to be taken care of, and I think the step that we would welcome as lawyers is if we get clarity on whether financial dispute itself will be arbitrable or not arbitrable, rather than looking at 5 judges, 7 judges, 9 judges, eventually 10 years down the line deciding this issue.
Right. Rightly put. Looking at my watch, just one last question, sir. Because looking at my watch, I see that we've already overshot the time thanks to the first panel, not to us, surely. Now we've all gathered here for I think a very good curated event by IDRC. That beckons me to ask, and I'll put this to Mr. Agarwal. How can arbitral institutions like IDRC and other ones mentioned CIAC, of course we're talking about Indian institutions, how can they develop specific rules to cater to the complexities of such complicated banking and financial disputes?
The question that you have asked has some relevance to whatever is happening around us in the country. Today, the financial ecosystem, particularly to give loans, is completely digitized. So now nobody goes to the bank to take loan, and nobody goes to the bank to repay the loan. Everything happens sitting at home. Entire process has got digitized beyond our expectations till about a couple of years ago also, and COVID has completely changed the scenario. So when the entire ecosystem, lending ecosystem is digitized, arbitration or the recovery or any other system should also be digitized. Even the legal system is now getting digitized to a large extent. That being the case, if we have to get digitized, then online dispute resolution by entities like IDRC are very, very important. Now the question comes how we can put it in rules. The moment we talk of anything to do with large numbers, large volumes, so rules will come into play by default, whether we like it or not. But there are three information streams that would be required to prepare those rules. One information stream is the regulator itself. We are all guided by Reserve Bank of India, and their guidelines keep getting changed every now and then. So your dispute resolution mechanism must have a direct information or awareness of what are the current or the latest guidelines of the regulator, which are very, very important today. Second is, it also gets impacted by the latest judicial orders in the law. So you need to have domain experts or the people who, or your rule engine should have a compendium of all the latest judgments which impact decision making. And third is something which I would say very few people would say in this kind of forum, is the own database of IDRC. When I say own database, IDRC would ideally become an institution like Edelweiss Asset Reconstruction Company. We deal with all banks. We acquire loans from all banks. So we see a trend that X bank has very good tight agreement. Y bank doesn't have the tight agreement. X bank has good credit policy. Y bank doesn't have good credit policy. X bank's documentation is perfect. Y bank's documentation is not perfect. So once you have your own database, you can make your own rules. And if it comes from a particular bank, we know that arbitration clause itself is not there. So why should we accept it? So these particular data points would get generated from the own database. So if you have three information streams coming here, and I'm sure the digitization or artificial intelligence or analytics has helped us in building rules, it won't be waiting.
Fair point. Fair point. With that, let's quickly open the floor to any questions. With paucity of time, we'll just take one last, please, to the gentleman between the two cameras.
Good evening. I'm Sunil Luthra, presently an advocate. Earlier, I was a banker. Only question is that in this whole discussion, largely the loans are settled through compromise and one-time settlement. That has not been a part of this discussion today. Still, I find that most of the loans, mainly that small ticket size and this unsecured loans are settled through OTS and compromises only. Because what we want in that there is less of hassle and more of recovery. Though we lose out some money in this settlement also, but still, so far as this arbitration or mediation is concerned, when we go to the court, they send us to the mediation or that arbitration, but normally that we straight away don't go for this arbitration. This is what is happening in the bank. So this is what my take on this is, and for that if the panel could say something about this, that why we still insist on going for one-time settlement and compromises only?
So, if I may just give a very practical answer to that. 100 crore loan, if you're taking from public sector bank, which officer do you think will want to write off 90 crores out of that? Nobody. So while one-time settlement is a good option, sir, once it's blessed by a judicial authority, and an officer will be more than happy to offer a one-time settlement in a judicial forum, because no onus will come on him or her that why did you authorize that? The last thing you want is a CVC investigation opened against you because you authorize a 90% haircut. So therefore, these judicial forums and arbitration, I'm giving a very practical example. They come in handy because there is nobody else who's willing to settle it. They say go to court, get it settled. The courts are burdened with cases. They say go to mediation and get it settled. So I think it's a very practical issue that we are dealing with, and you are absolutely correct that most of these cases end up getting settled, but the question is who will do it and why will they do it?
Let me just give you one.
Yes.
Yeah.
Of course.
Let me just give you one small point there. All lenders are commercial organizations. Their objective is not recovery. Their objective is also recovery at what cost and in what time frame. So particularly when we come to smaller loans, your question was why don't we by default go to the arbitration or mediation? So the reason people still don't want to go to arbitration because commercial banks or lenders have not seen the real advantage coming out of approaching the arbitration centers, because it becomes a time consuming and expensive exercise at a portfolio level, not at individual account level. So if at a portfolio level it is not worth its while for me, I would rather prefer to take a haircut and move on. I am more concerned about what is the net impact on me rather than individual account or doing some kind of intellectual discourse there. So if arbitration as a product moves up, it is in the interest of banking world, it is in the interest of borrowers, and it is in the interest of people like us. Because at the end of the day, as I said earlier, borrowers are young, they need to grow, they need to borrow more, and it is in their interest to settle the loan at a price where they can borrow more tomorrow. They need a clear credit history. So which is where arbitration, if it succeeds, is going to be to the benefit of all of us.
I think there's a day closer now where we have the OTS settlements as, if you have arbitration there, we can always enforce those awards as settlement awards. So that's another benefit of arbitration for OTS settlements. Well, with that, we come to the end of the session, and we don't want to stand between the audience and Friday night plans. So thank you to all the panelists for a very enriching and stimulating session. And thanks to the audience for bravely waiting it out for this hour. Over to you, Divyansh.
Thank you, sir. I would like to extend my heartfelt gratitude and thank our esteemed panelists for the second panel discussion, Ajit Kumar Mishra, sir, Sanjay Agarwal, sir, Amit Goyal, sir, and Aseem Chaturvedi, sir. I would like to thank Shashwat Bajpai, sir, Dr. Shashwat Bajpai, sir, for effectively and efficiently moderating the session. It has been our pleasure to hear the thoughts of the panel on one of the most trending topics of arbitration and banking and finance disputes and its way forward. And I hope the discussion by the esteemed luminaries and the panel has definitely brought a more clarity on the topic of panel discussion has shown the way forward in arbitration in banking and finance disputes. I would like to extend my sincere gratitude to Manan Kumar Mishra, sir, Senior Advocate and Chairman, Bar Council of India and Member Rajya Sabha, for sharing his views in his opening address on arbitration in India and initiatives taken by Bar Council of India. This event would not have been successful without his support and support of India International University of Legal Education and Research, GOA, which is the initiative of Bar Council of India, to which we would like to extend warm gratitude for joining as principal academic partner. I would like to extend my sincere thanks to our esteemed panelists for the first panel discussion. I would like to thank Honorable Justice Hima Kohli, former Judge Supreme Court of India, Attorney General of India, R. Venkata Ramani, sir, Tejas Karya, sir, Head Arbitration, Shardul Amarchand Mangaldas, Ratan K. Singh, sir, Senior Advocate, and Arush Khanna, sir, for moderating the panel discussion on institutional arbitration, Ad-hoc versus institutional arbitration, and India as a hub for institutional arbitration. I have a firm belief that the healthy exchange of thoughts in the panel discussion will take a fruitful course to make India a hub of institutional arbitration. I would like to thank Arush Khanna, sir, Partner Newman Law Offices and Ambassador India Vienna International Arbitration Center, for moderating the panel discussion and joining us as a representative of Vienna International Arbitral Center. I would now like to extend my heartfelt gratitude to our gold partners Aditya Birla Group and EY India for supporting the third Arbitrate in India conclave. I would like to thank our supporting organization, without whose support this conclave would not have been successful. I would like to thank Shadul Amarchand Mangaldas, Ratan K. Singh Sir, OP Jindal Global University, Trademark Lake, Sandeep Logistics, Indian National Bar Association. I would like to thank our knowledge partners, Vivekananda Institute of Professional Studies, Indian Institute of Arbitration, Indian Institute of Mediation. I would now like to thank our media partners for covering today's conclave, latestlaws.com, Z News, Haribhumi, and Janta TV. I would like to extend my special gratitude to our respected board of advisors and members for their constant support and guidance. I would like to thank Manoj Sharma sir, our IT head, and his team for working tirelessly to develop IDR's EADR software, website, and cloud infra. I would like to extend thanks to our team members Sunny Chikara, Ankit Kumar, Pratibha Badoria, Siddharth Raghuvanshi, Akash Kashyap, and Dharmender for their hard work, without which this conclave would not have been successful. I would like to thank our esteemed guests and audience for joining us at the conclave today. We are highly obliged to have you with us today. I would like to thank India International Center, their staff and service providers, and Delhi Traffic Police. With this, we look forward to having you at our next conclave, and thank you for coming and joining us today. I would now like to request the panelists to join us for a group photograph, and I would like to request the organizing members to please join for the group photograph. Thank you. Thank you so much. I would request also our invited guest and panelists to join us for the